Did to mention a matter, Your Lordship, for correction of the order, Your Lordship.
What is the correction?
3 corrections are there. Order. The second paragraph, the name has been wrongly recorded as MC Electorate. It will be Electro, MC Electro. In the second page, Your Lordship, the date is 28th, which is 20, Your Lordship. 20, and the name of the nominated arbitrator will be Ratul Das, Your Lordship.
Just make the correction to be mentioned tomorrow.
Grateful, Lordship.
My lord, with my lord's leave, may I please mention a matter seeking listing of a section 34 application which I have filed before my lord. Due to certain procedure difficulties, my lord, the application has not been numbered and I shall receive it today by 1 o'clock and I shall hand it over. My lord, the urgency is that it's a interim award that has been passed in an arbitration between Damodar Valley and HRD Builders, and the arbitration is listed on next week, Wednesday, my lord. My lord, Senior Advocate Abhinav Mishra is traveling to Calcutta on Thursday to address my lord on the merits. If my lord may consider hearing. Oblige, my lord.
Listed matter, item number 1.
Lordship, this is our, I'm appearing on behalf of the petitioner. This is our 29A application. This is our affidavit of service. Kindly keep it in your record.
On the other side, madam.
Your Lordship, we have served to the other side. Advocate on record.
Are they appearing in the arbitral proceedings?
Your Lordship, the witness action is already completed in
Are
this.
they appearing in the arbitral proceedings
Yes,
for the traveler?
yes, Your Lordship. Your Lordship, the witness action is already completed in this matter. It is in the final stage of the hearing.
Where have you served them?
Sir, to
Serve
the
the lawyer.
advocate on record of the Sumitra projects.
Serve the petitioner, the respondent. Why are you serving only the lawyer? Serve upon the respondent. Respondent counsel for the petitioner. Petition is granted. 2 weeks time to effect service upon the respondent. It's after 2 weeks. Serve the respondent. Take it back. Serve upon.
Item number 2.
Yes, who's there? For the petitioner.
My lord, I appear, my lord. I'm sorry, my lord. I'm a little late. Item number 2, my lord. My lord, kindly permit me, my lord. I'm sorry, my lord, on a virtual mode. My lord, today I'm at Chandigarh, my lord, at Punjab Haryana High Court.
All right. Good.
My lord, this is a section 29 capital A application.
Yes.
My lord, my
Who's
lord,
on the other side?
my lord, I am told, my lord, this other side has already been served. There are 2 respondents. My lord, I am assisted by Mr. Obidipto Tarofdar. I do not know whether he is in their court or not.
Also not here.
Whether the service is complete.
Service is not complete.
I'm told, my lord, that's, but in any event, my lord's brief, my lord, should state the correct facts. I'm just now told, my lord, the service is made upon all the respondents, my lord. They're already, my lord, is.
Mr. Vasu, you have only served upon the respondent's lawyer. Serve upon the respondents. What is this practice of serving
My
upon
lord,
the lawyers?
my lord, since, my lord, this is already arbitration process.
Right, but then nobody is here. At least somebody should have been here.
Correct, my lord, correct. Correct, my lord is
They are
absolutely
not
correct.
here. Then I would like the service to be effected upon the respondents.
Lordship. They were served. If they choose not to, then we should serve upon the respondents. Uh, day after.
You serve upon the respondents. When do you want it? Next week or next to next week?
Next week. Next week.
Keep it up to 1 week.
25, would it be convenient? Next Tuesday.
Next Tuesday, yes.
Next Tuesday. But I'm sorry, to keep
Take that granted liberty to serve upon the respondent.
Malad may note that this service was there, but we shall make service again, Malad.
That's what I've stated.
Yes. Grateful. Sorry for keep your lordship in trouble.
No problem.
Please.
Yes.
Extremely obliged.
Next week. 3.
2 weeks.
Lordship, I am appearing on behalf of the petitioner. There is an application 29 application.
Where's the service?
The service has been done. It's hand service.
To whom? To the
To
lawyer?
the respondent.
The lawyer of the respondent?
Company ka to? It has been respondent company. The hand service has been under the respondent company.
Yes. Affidavit of service taken on record despite service none appears for the respondent. Yes, tell me now.
Lordship, this is the 6th extension which we are asking for before your Lordship.
Yes.
The claimant has already
Where's the
concluded.
last extension page?
Lordship,
Where is the last extension granted by the court page?
on your Lordship on 29 July 2025. Page 21, your Lordship.
Yes, tell me the facts.
Lordship, the claimant has already concluded the submission in the 31st meeting. Since then, the respondent are submitting their submissions. Therefore, 2 applications has been filed on behalf of the respondents for additional evidence. The first person which was filed, the person left during the cross-examination from the arbitral proceeding and never came back. The second application was for a person who was there in the arbitral proceeding right from the beginning and was even assisting the counsel for the respondent. Thereafter, that
When
application.
was the arbitrator appointed, sir? You don't know when the arbitrator was appointed?
Lordship, please give me 1 minute, Lordship.
To do this homework before. How many briefs you have today to argue?
Lordship,
How many briefs you have today to argue?
Lordship, only 1 brief.
Then, still you're not prepared. Come back next week. Please know your fact. Assist the court. Get an opportunity, you just don't even cash it.
Right.
Next week, not today. Thank you. Recording. Hello.
Motion section 37 and number 4.
But I am for the respondent. But here, if your lordship, I'll just give a short background of what my learned friend has argued, it was quite some time back. That is a challenge. Challenge to a order passed by the learned arbitrator in a section 17 application. The points which my learned friend, a commissioner has been appointed to inspect the property. That atmosphere. I remember now. Right. One of the points basically which has been taken, one is a jurisdictional point which I believe Mr. Shah has taken, that if it's a RERA, if it goes under RERA, RERA is exclusive and everything must go to RERA. It's a dispute in REM. That is what he has more or less argued. But before I go there, certain facts I think he has argued the overlapping between the RERA and the appointment of the, right? Well, yes, for that reason, I would like to just correct a few facts and then we'll go there, then I'll take up his argument. But a few facts, your lordship will kindly, these are admitted position. I, that is the respondent, who's the claimant, is not a party in the RERA proceeding. But second, this arbitration arises out of a conveyance, yes, in favor of my client, which contains the dispute resolution for the nature of an arbitration. There were section 9 applications filed here before this court, where it ultimately landed up before a division bench of this court, where it was decided and liberty was given to me to go before the tribunal for all kinds of relief, whatever I am supposed to get. Next, kindly appreciates what have I sought for in my statement of claim. I basically sought for specific performance. Yes. With humility, I say, take your lordship through the RERA. It cannot provide specific performance per se. I'm only espousing my individual rights. I'm not there to espouse any other's rights. So the first thing which my learned friends have been continuously harping, not only here, but also before the learned arbitrator, was that this is a multiplicity of proceedings. But a multiplicity of proceedings, I say, without me being a party, does not arise at all. Yes. And it is also a statutory right which I am also invoking under the arbitration constitution. So this is my first point. Second point which my learned friend was trying to make out on facts, only on facts. Second, I would like to point out, if the lordship takes up the order, your lordship will find 5th of February order, right? Yes, ma'am. It is at page 30, yes, of the stay application. Yes. There were several points taken by both parties. No dispute about that. But another point I must point out, this point of jurisdiction and non-arbitration should have been taken up in a section 16 application. For the point to be established, first things first, whether he can take up this point at this moment, yes, as a jurisdictional point, because he has already filed the statement of defense. Yes. And there is no section 16 made. This is more of an afterthought, as a point in the appeal, because this point was really not taken up or taken before the learned arbitrator. The point taken was multiplicity of proceedings, but not that RERA, since it's RERA, therefore it becomes non-arbitrary. That point was presumably not taken. Then, kindly, if your lordship kindly sees, I'll take your lordship straight, if your lordship permits me, the findings, let us try and narrow down the scope, Finding is, 51. Page 51, your lordship will find data will kindly come to page 53.
So you have some issue with the common area.
Sorry, but
You have got some issue with the common area, right? That's
That's
the
point.
entire controversy.
yes, because my lord, I have been given common area conveyed under the Act, Transfer Property Act. Now, on that, my lord, a flat has come up. One, and what has been directed just to take inspection of the area. And my lord, there are 2 penthouses which also come up on the terrace. These are the two, because my lord kindly appreciates the common areas are these. Now these have been taken. Now I cannot also go above the penthouse for the terrace also, because that has become private. So these are the disputes which will go to the arbitrator. Arbitrator will see that. Now, why does the arbitrator pass this order? That becomes very important. And then I'll take your lordship to the jurisdiction part. When it kindly comes to page 52, paragraph 9C,
The core issue in
the core issue is whether the construction of the additional flats and construction at the deck level in both the towers are legal or valid, or whether they have infringed the terms and conditions contained in the sublease granted to the claimants and applicants, which will be decided finally in this letter. So this is the scope. And while it kindly keeps note that this is by way of a conveyance, I'll point out why, Mallet. And with humility, I'm just making this point, Mallet. RERA will not see anything beyond the conveyance. If the conveyance is over, then it becomes, Mallet, a dispute between the parties. RERA will only see that the agreement for sale and the conditions for handing over allotments, Mallet, are complete. This, your lordship, is post that. Mallet, let us take a situation, Mallet. The dispute arises after 10 years. It's not RERA restricted.
One thing.
Mallet.
Mr. Dey, all these flats would have come up with the sanction of the authorities concerned.
Yes, Mallet.
Just for my
Yes, Mallet.
understanding. So even if, when we go to the arbitrator, even if it is held to be illegal,
Mallet.
what will you get?
Will I get? Mallet, either I'll get, Mallet, specific performance decree, which I can enforce, or I'll get damage.
Damage is the only thing which you can.
No, Mallet, I can also get a specific performance if I want to, Mallet. Mallet, that I don't think will be a problem, Mallet. Because, Mallet, your lordships will then have to execute that as a under order 21. But again, Mallet, that is a high level of hypothesis, Mallet, because I don't know what kind of a word I can get. But I've sought for specific performance.
I was just trying to understand what
Mallet,
ultimately.
obviously, Mallet, obviously. I do appreciate Mallet. Because, Mallet, the common area is not just common, Mallet. There were other things to be there, Mallet. Mallet, that E-deck level was only meant for common, Mallet, facilities, where another flat has come up. Now, Mallet, kindly comes to, since I'm on this finding, Mallet, finish with this and then come to your logic at that point. But kindly sees D. It is noted from the pleadings of the respective parties and arguments advanced in support thereof that the case of the claimants is diametrically opposite to the respondent. While claimants contended that the additional constructions were illegal, infringe their rights to common areas, and further, no consent of two-third allotments were obtained to carry out the additional construction as per RERA. The respondent contended that no consent of two-third allotments were necessary as RERA provisions did not apply. This is what they were saying. When additional constructions were carried out as per modified sanction plan, and the claimants were all along aware of those construction, right to common areas has not been infringed. Further, there is already an order of inspection by KMC passed by RERA, and there is no necessity to pass similar order in this procedure. So both the sides, their contents are captured. Now, let's see what the order is. Both parties file notes of argument. In the backdrop of rival contention noted above, the arbitral tribunal feels. So, it's the suo motu. It's a right also of the tribunal to look into it and inspect if it requires. Now, see, the tribunal feels it is necessary to obtain clear picture of the state and condition and extent of the construction. State, I think that should be not in capitals, state, condition and extent of construction complaint of which would be a great assistance to the arbitral tribunal. to decide the core issue in this reference vis-a-vis the contents of the respective party. So, my lord, today the tribunal, my lord, I had invoked the section, my lord, there is no dispute. But, my lord, the arbitral tribunal, on its own suo motu powers, had sought for an inspection, which it can do, my lord, if your lordship kindly sees, and it takes up, my lord, kindly sees, my lord, 17. A party may, my lord, kindly
17C.
my lord, 17C. Inspection of any property. And, my lord, also, my lord, if your lordship kindly sees, my lord, section 26 also. My application was not under 26. But the tribunal, my lord, has every right to appoint an expert commissioner, my lord, on the specific issue to be determined by the tribunal. So today, my lord, the tribunal says that the tribunal needs for better understanding. In my application, my lord, I had also said so. So, my lord, the question before your lordship is this perverse? And your lordship is well aware, my lord, the scope is only to the extent of perversity. And in a section 37, my lord, from a section 17 application, will this be perverse? And, my lord, your lordship, I don't want to show judgments for this, my lord. My lord, the test of perversity is the reasonable man's approach today. That's established. But is it so perverse that there is a dispute with regard to the area a commissioner is going to go on whatever time? Commissioner, some person, sorry, it might be surveyor, will go and inspect and measure it. And the tribunal says, I need to know this to find out. This is the scope. So, my lord, on the point of the order being perverse with humility, I say, my lord, there is no perversity and everything has been dealt with, my lord. All points have been dealt with. 26 pages of order, my lord, dealing with entire pleadings, notes, everything has been dealt with. Now, my lord, let us come to this point, my lord, of the question of RERA Act and, my lord, it overcoming, my lord, all other acts. My lord has a book.
Which one? That RERA?
Dark down on the RERA Act.
Yes, I have.
Well, it kindly sees, well, at first. Well, let us first go to the powers of RERA under the RERA. First, well, it kindly sees this will be, well, under chapter 5, starts from section 20. Then, my lord, your lordship will kindly straight away come to section 31.
Yes.
Any agreed person may file a complaint with the authority or the adjudicating officer, as the case may be, for any violation or contravention of the provisions of this act, or rules made thereunder against any promoter, allottee, or real estate agent, as the case may be. Now, my lord, kindly see 32.
Yes.
My lord, the functions. Protection of interests of the allottees, promoters and real estate agent, creation of a single window system for ensuring time-bound project approvals, creation of a transparent and robust grievance redressal mechanism against acts of omission and commission of competent authorities and their officials. Then, my lord, others are not really very important, my lord. My lord, there is this J, my lord, which is an omnibus subclause. Any other issue that the authority may think necessary for the promotion of the real estate sector. And then again, my lord, section 34. My lord, this is an overview of the development and my lord, more of a, my lord, a protection on the allottees. I am no longer an allottee, my lord. I have been given on a conveyance. Then, my lord, kindly sees kindly straight away comes to, my lord, I'll take the point now, my lord. Kindly comes to section 88, my lord. That kindly takes 88, my lord. The provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being. So it should be in addition. 88. Section 8. So, my lord, and 89 is obviously there, my lord, that the provisions of this act shall have effect, notwithstanding anything inconsistent therewith. Now, my lord, if it is not 89, then 88 obviously, my lord, sanctions another act to apply. But here, my lord, kindly appreciates it's a specific performance. First of all, can the RERA give me a specific performance? That's a question which I'm asking myself. First, my learned friend, I'm relying on his submission, that it's an action in rem because it's under the RERA and it involves all allottees. But I do have an individual right under the conveyance. And that cannot be an action in rem, my lord. Therefore, my lord, this was provided for. But just for the completeness, my lord, I should also point it out, being an officer of court, my lord. Section 79 kindly appreciates, my lord. There is a bar of jurisdiction. My lord, that is only in respect of any matter which the authority of the adjutant officer is empowered by or under that. And again, I say, my lord, it is not, my lord, a simpliciter, my lord. It cannot decide, my lord, disputes in personam between two parties. And the Arbitration Act, my lord, or an arbitration agreement is not, my lord, rendered nugatory by this act. Now, my lord, this section has been considered, my lord, by the Supreme Court also, my lord. I will be referring to that. But before that, my lord, may I straight away show your lordship the judgments which Mr. Shah has relied upon, my lord. And then I will take your lordship to the judgments which I would like to rely upon, my lord. 2021 PCC, page 1. Copy. The first one is, my lord, 2021 2ACC, page 1, that is with their Trolia, my lord.
Yes.
My lord will kindly see paragraph. Oh. Just gives you a moment. Sorry, my lord.
Para 55, 75, 76.
Yes, my lord. My lord, kindly see 55, my lord. Doctrine of election to select arbitration as a dispute
What is the
resolution mechanism.
internal pages?
Sorry, madam. Internal page. Yes, yes, madam. I'm sorry. Madam, that should be page 64, madam. 63 to be precise, sorry. It's page 1, madam. Therefore, madam, the same page. Madam.
Internal page of the judgment. Tell me the internal page of the judgment.
Like 63
63.
on the right hand top.
Paragraph?
Para 55, madam. Our copy.
Yes.
How come? Why? Why?
Yes.
Madam.
See, 83 here. I don't know. This is on. It's all right.
But I'm not too sure whether it's up to the SCC then, madam. I'm on a
See,
SCC. Sorry, madam. On para 55.
Yes.
Doctrine of election to select arbitration as a dispute resolution mechanism by mutual agreement is available only if the law accepts existence of arbitration as an alternative remedy and freedom to choose is available. But there is no bar, even under the RERA. There should not be any inconsistent repugnancy between the provisions of the mandatory law and the arbitration as an alternative. This is basically following relying upon Booz Allen for actions in rem. There should not be, conversely, and in a given case when there is repugnancy and inconsistency, the right of choice in election to arbitrate is denied. This requires examining the text of the statute, the legislative history, and inherent conflict between arbitration and the statute's underlying purpose, with reference to the nature and type of special rights conferred and power and authority given to the courts or public forum to effectuate and enforce these rights and the orders passed. When arbitration cannot enforce and apply such rights, or the award cannot be implemented and enforced in the manner as provided and mandated by law, the right of election to choose arbitration preference for courts or public forum is either completely denied or could be granted. Now, the question fell from your lordship, what can I get? I can get specific from. Then, kindly sees your paragraph. In essence, it is necessary to examine if the statute creates a special right or liability and provides for the determination of each right or liability by the specified court or the public forum so constituted, and where the remedies beyond the ordinary domain of the civil code are prescribed. When the answer is affirmative, arbitration in absence of special reason is contraindicated. The dispute is non-arbitrable. Then, the first thing we have to identify is the dispute. And whether that dispute is a dispute contemplated under the RERA in this case. Then, it straight away comes to paragraph 76. We have the above discussion. We would like to propound a fourfold test for determining when the subject matter of a dispute in an arbitration agreement is not arbitrable. When cause of action and subject matter of the dispute relates to actions in rem. There is not an action in rem. And that do not pertain to subordinate rights in personam that arise from rights of in rem. That is also very important. That do not pertain to subordinate rights in personam that arises from rights in rem. This has been explained a little bit later. I'll just point that out. When cause of action and subject matter of the dispute affects third-party rights, have erga omnes effect, requires centralized adjudication, and mutual adjudication would not be appropriate and enforceable. Again, that's not the case because my rights arise from the conveyance. When cause of action subject matter of the dispute relates to inalienable sovereign and public interest, that is not here, of the state, and hence mutual adjudication would be unenforceable. But the subject matter of the dispute is expressly or by necessary implication non-arbitrable as per mandatory statute. When I say section 88 is contrary, then these tests are not watertight compartments. They dovetail and overlap, albeit when applied holistically and pragmatically will help and assist in determining and ascertaining with great degree of certainty when, as per law in India, dispute of subject matter is non-arbitrable. only when the answer is affirmative that the subject matter dispute would be non-arbitrable. However, the aforesaid principle should be applied with care and caution, as observed in Olympus. A reference is made therein to certain disputes, like criminal offences of a public nature, disputes arising out of illegal agreements, disputes related to status such as divorce, which cannot be referred to arbitration. It has, however, been held that if in respect of facts relating to a criminal matter, say physical injury, if there is a right to damage for personal injury, then such dispute can be referred to arbitration. So, I'm trying to narrow it down as far as possible. But then I can claim damages. Even if I take Mr. Saha's argument hypothetically to be correct, then also I can have arbitration. Then kindly sees, similarly it is held that a husband and a wife may refer to arbitration the terms on which they shall separate, because they can make a valid agreement between themselves on that matter. But similarly, here also, I am the lessee, he is the lessor, husband and wife. That's the mutual agreement. Two persons. Applying the 77, applying the above principles to determine non-arbitrability, it is apparent that insolvency or intra-company disputes have to be addressed by a centralized forum, be the court or a special forum. It will be more efficient and has complete jurisdiction efficacious and fully dispose of the entire matter. There are also actions in rem. And a grant of issues and registration of trademark also had been held that. And accordingly, it just specifies actions in rem will not be arbitrary. Now, the next judgment which 2021 this is 2021 SCC online Madras 16554.
Para 23.
23 malad. Malad 23 malad is malad on the provisions of section 7 malad. Then malad kindly sees it talks about the rules of the Army Welfare Housing Organization, which had a arbitration clause.
Para 27 onwards.
27 onwards, yes, malad. It is already found that if a special statute creates a special right or liability and provides for the determination of each right and liability for the specified court or the public forum so constituted, and whether the remedy is beyond the ordinary domain of the civil courts are prescribed, and the answer is affirmative, the dispute is not arbitrary. So, I again say my rights are for specific performance, and the Act does not provide for that. Act says you complain. It's a regulating body. My civil rights under the specifically fact that is not barred, and obviously section 80 is also there. It says that it is in addition. Then kindly sees 28. It only says that with regard to the what is the scope. Then 29 talks about the objects and reasons. Now, if your lordship kindly sees the objects and reasons, because this was also referred to by my learned friend. Kindly sees the object and reason in the act. Just see an act to establish the Real Estate Regulatory Authority for regulation and promotion of the real estate sector, and to ensure sale of property, apartment or buildings as the case may be, or sale of real estate project in an efficient and transparent manner, protect the interests of consumers in the real estate sector, establish an adjudicating mechanism for speedy dispute redressal, and also to establish the appellate tribunal to hear appeals, decisions, decision orders of the real estate regulatory order and the adjudicating officer, and for the matters connected therewith or incident there. So, man, it's only related to the functions of RERA, nothing more than that. And that is the preamble also. Then my learned friend has referred to paragraph 31. May I just take your lordship to 31st and then 31?
Yes.
30 times. Does this act as provisions for registration of real estate projects and real estate agents? Definition of the functions and duties of the promoters, rights and duties of allottees, establishment real estate regulatory authority, real estate appellate tribunal, defining their function and powers, and importantly, providing penalties for the offences committed under that. Section 59 to 69 of the Act deals with the offences, penalties, and adjudication. Section 70 deals with compounding of offences. Certainly, arbitrator cannot impose penalty and imprisonment. I'm not asking for that. That was the basis on which this was founded, this judgment. Then it goes on to say, therefore, considering the nature of the dispute involved, it's not as if it's an absolute bar. Considering the nature of the dispute involved in this case, with the petition and the respondent, the arbitration was a one-sided agreement, giving no option to the respondent in the choice of appointment of arbitrator. The dispute involved in this case is covered under RERA. Once I finish with their other last judgment, I will show your lordship the judgment of Justice, the division bench headed by Justice Shaw mentioned. Your lordship will find that they were also parties. Now, Malad kindly takes the Bombay judgment, very interesting judgment, Malad. Malad, the Bombay judgment. That progressive lens has become a major problem in life.
Even I have to remove it.
I mean, that's a problem, and it doesn't look good that I am always keeping this like this one before lordship. I don't do that. Now, once I remove this one, I can't see a lordship. And once I don't remove it, I can't see properly here. And I have another problem, Malad. If I can't see properly, I can't hear properly. It's a major problem nowadays. Now, Malad kindly sees the judgment. Malad, this is, if your lordship has got that, Malad, 2024 SCC online, Bombay 3871. But kindly, well, this, if your lordship kindly comes to paragraph 9 first one. But kindly sees this is a venture with humility, I say, of the entire persons involved in this case, including the honorable judge, to answer an issue which was not an issue. Kindly sees 9. Before considering the main issue, where the dispute between the parties is non-arbitrable, in spite of the arbitration clause contained in MOU executed between both the parties, it is necessary to ascertain the criteria for determining non-arbitrable nature of the dispute. Now, while dealing with the entire Arbitration Act and the RERA, kindly comes to paragraph 53, This will be page 5.
Yes, page 55. Yes.
It is also settled legal position that doctrine of election to select arbitration as a dispute resolution mechanism by mutual agreement is available only if the law accepts the existence of arbitration as an alternative remedy and freedom to choose is available. There should not be any inconsistency or repugnancy between the provisions of the mandatory law and arbitration as an alternative. Conversely, and in a given case, when there is repugnancy and inconsistency, the right of choice in election to arbitrate is denied. This requires examination of the text of the statute, the legislative history, and the inherent conflict between arbitration and the statute's underlying purpose. Malat kindly keeps this on note, Malat. The judge himself says you need to look into the text of the statute. But with humility, I must point out that section 88 has not been considered in this judgment, Malat. Your Lordship will then find, Malat, there is a conclusion. '54, Malat kindly sees. It is settled legal position. When arbitration cannot enforce and apply such rights, or the award cannot be implemented and enforced in the manner as provided and mandated by law, the right of election to choose arbitration in preference to the courts or public forum is either completed or could be curtailed. I say, Malad, it is not something which the arbitrator cannot pass. The arbitrator can definitely pass orders, Malad. So the parameter which has been set in this judgment also, Malad, but it carves out that it is specifically only those which are under RERA and arbitrator cannot decide that, then it becomes non-arbitrable. Then Malad kindly sees it's a then Vidya Dolia has been noted, Malad. But your Lordship will find paragraph 59. Mr. Shah, Malad, presumably has not placed paragraph 59, I believe, Malad. I just place this, Malad.
No, you're not.
Thus, on the touchstone of the well-established parameters for determining the non-arbitrary nature of the dispute, it has to be held that the dispute which is covered under the RERA is non-arbitrable, and therefore jurisdiction real estate authority under section 20 is not ousted. It's the contrary finding, Malad, that arbitration has ousted RERA. No. I've also not said that, Malad. So therefore, Malad, this judgment to say that it says that arbitration, or in this case, it is non-arbitrable, Malad, presumably may not be correct also, Malad, in the reading of this judgment, Malad. Now, Malad, may I take your Lordship? I'm coming back to my judgment, but before that, I'll just show the division bench order, Malad. Malad kindly comes to page 685, Malad, of the petition of the supplementary affidavit. Supplementary affidavit, volume 1.
Volume 5.
Volume 5. Volume 5, volume 5. Page 665. And I got that. 665. But consider the party that we have taken up. Now, the petitioners are the allottees and included of flats in a residential complex known as atmosphere. Luxurious condominium complex consisting of 2 towers. The dispute arose when the appellant developer started being concerned in respect of 2 penthouses in edicts as described in the Schedule P of the arbitration. I think that's a long recording. Then Malad kindly straightaway comes to Malad para 5. Rather, they have been protected by this order. In view of the fact that substantial construction has already taken place and the modified building plan has not yet been revoked, prima facie the applicant has right to make construction of the penthouse. This, however, is subject to any proceedings that the KMC might initiate or contemplate, and any such construction shall abide by the result of the arbitration proceeding. In the event the penthouse of construction is transferred and alienated transferred, it shall not be entitled to claim any equity in the event. Ultimately, is contained and held that such construction is unauthorized or not permissible on true construction of the sale deed executed in favor of the respondent. And insofar as the edict, my lord, the positive evidence of petitioner was that such and such is utilized, and then, my lord, the counsel appearing for my learned friend's client, construction made was beyond the said area, and in fact, one of the constructed has been sold in favor of one Ambika Peri. It is needless to mention that in the event, well, kindly see,
Where are you
the
reading?
ultimate,
Which-
sorry, man, it is page 668, man.
Yes, yes. Which para?
Well, it's starting. It's just for February
Needless to
2024. man. It is needless to mention that in the event it is ultimately found that such construction is beyond the agreement or the sanction plan or the modified sanction as the case may be, the petitioner shall be entitled to seek such relief as will be advised in the arbitration proceeding or before the appropriate. And then, my lord, 8, by consent of the parties. My lord, they consent to go to arbitration. But why I'm saying this, I know, my lord, if you consent to go to arbitration, you are entitled to take the point of jurisdiction. No dispute about that. But, my lord, we are looking to the prima facie case at this point of time. There is no section 16. They have filed their statement of defense. And now to come and say it doesn't have jurisdiction and the arbitrator has not, my lord, dealt with this, my lord, is something which is, my lord, is an afterthought and should not be taken, my lord. And, my lord, what has the arbitrator done? He says for himself, he needs to know. My lord, I was there personally present, my lord, in the arbitration also, in the section 17, my lord, but it involves huge plans. So, my lord, the arbitrator felt that he needs to look into it from a perspective which he would understand. Now, my lord, kindly comes to a few judgments, my lord, which I would like to show to your lordship, my lord. My lord, for only for the purpose of completeness, my lord, I am formally relying on 2024-11 SCC 351. This is Ambala Choksi, my lord. Only for the proposition that if it's not perverse, there should not be any interference. And the same principle would apply even in a section 37. Rather, in a section 37, it's narrower. It's narrower. And may I just but from paragraph 19, your lordship will find the discussion is on the appellate jurisdiction under order 43 minutes. Then your lordship will kindly come to paragraph 32, 33. One of the principles of governing grant of temporary injunction, that is at internal, the judgment page 367, on the right. Just before the para 31, just for the completeness, the appellate court in an appeal from an interlocutory order granting or declining to grant interim injunction is only required to adjudicate the validity of such order, applying the well-settled principles governing the scope of jurisdiction of the appellate court under order 43, which have been reiterated in various other decisions of this court. Appellate court should not assume unlimited jurisdiction, should guide its power within the contours laid down in the Wonders case. Then, principles governing grant of temporary injunction, then prima facie and irreparable injury, those three cases have been mentioned. Then, kindly comes to para 34, the next page, Any order made in conscious violation of pleading and law is a perverse order. And para 35 deals with several definitions in several dictionaries. And then para 37, sorry, 36, I'm sorry. 36, kindly says, the wrong finding should stem out on a complete misreading of evidence, or it should be based only on conjectures and surmises. Safest approach, kindly says, on perverse, it is the classic approach on the reasonable man's interference on the facts. To him, if the conclusion of the facts in evidence made by the court below is possible, there is no perverse. If not, the finding is perverse. Inadequacy of evidence or a different reading of evidence is not perverse. And then para 37 found that it was not perverse. So that is the test. But I have taken your lordship through the findings. The main finding I have shown your lordship, and that is definitely a plausible finding which the arbitrator could have reached while he came and identified the dispute. It involves the area. And that is what the learned arbitrator has done. He said, I also need to know. Other than I have said that, yes, I need to know. And also that test, what prejudice is my learned friend is going to undertake. He says third party rights will be disputed. Where, if I ask myself, they're just going to go out and just measure the outsides. They're not going to enter any premises. That is the scope of the order. Now, may I take your lordship a few other judgments, It kindly takes,
What are you seeking in the arbitration?
I'll point to the statement of claim, Statement of claim. And rather saying, I would rather point it out from the pleading. So just give me a moment, It's at page 101, 100. Stay application volume 1, There starts at page 115, An award for declaration first that it was contrary to the indenture of the sublease. And also C, your lordship will find. And the negative, it's a enforcement of my sublease by not allowing them to carry out any constructions contrary to schedules B, 1 and 2, which is contrary to the indenture of lease, which contains the arbitration clause. And the other consequential orders, all arising from the sublease. And kindly appreciates, this is post-allotment. This is post-allotment, after conveyance. But if this was the point, then what would happen, if I agree to the proposition of Mr. Saha, then there would be no other specific performance suit. That would come to a complete standstill. My case is that this is what was given to me under the conveyance. You have violated that. Please adhere to it. And for that, whatever consequential relief I want, I can get, I will get. Because, my lord, with humility, I say my learned friend has referred to the RERA, but he has not specified, subject to correction, the specific provision under which these orders could have been passed. Now, my lord, kindly takes, my lord, this is 2022, 2022, 15 SCC 286. Experienced developers, Sushma Shok Shivu, 2022, 15 Supreme Court cases. But kindly have a look, Malad, from paragraph 19, Malad. Malad, kindly have a look. Sorry, Malad, I should have shown the other judgment first, Malad. On whatever, Malad, may I just take your lordship to para 19? Yes. The question is no more res integra. In Imperial Structure Limited, will also call that I refer to the next one. This court, speaking through Justice Sensor, examined the jurisdiction of Consumer Forum vis-a-vis the specific remedies created under the RERA Act. This judgment comprehensively deals with all aspects of parallel remedies available to the consumers under the Consumer Protection Act and the RERA Act. In Imperial Structure also, like in the present case, proceedings are under the decision of the Commission under the Consumer Protection Act. After a comparative analysis of both the statutes, this court held as under. It has consistently been held by this court that the remedies available under the provisions of the Consumer Protection Act are additional remedies over and above the other remedies, including those made available under any special statute. That the availability of an alternative remedy is no bar in entertaining a complaint under the Consumer Protection Act. Similarly, here, Malad, section 88. Before we consider the provisions of RERA have made any change in the legal position stated in the preceding paragraph, we may note that the allotee placed in circumstances similar to that of the complainants would have initiated the following proceedings before the RERA Act came into force. And he could have gone to the Consumer Forum and Malad, kindly see C, Malad. If the agreement with the developer or the builder provided for arbitration, he could, in cases covered under clause B, here and above, he could initiate or could be called upon to invoke the remedies and arbitration. But I'm just reading the relevant parts. It will take a lot of time, Malad. Then, Malad, kindly comes next page. In terms of section 18 of the RERA Act, if a promoter fails to complete or is unable to give possession of an apartment duly completed by the date specified in the agreement, the promoter would be liable on demand to return the amount received by him in respect of that apartment if the allotee wishes to withdraw from the project. Such right of an allotee is specifically made without prejudice to any other remedy available to him. The right so given to the allotee is unqualified and never availed. The money deposited by the allotee has to be refunded with interest at such rate as may be prescribed. The proviso to section 18(1) contemplates a situation where the allotee does not intend to withdraw from the project. In that case, he is entitled to and must be paid interest for every month of delay till the handing over the possession. It's up to the allotee to proceed either under section 18(1) or under proviso to section 18(1). But then kindly see 26. It is therefore required to be considered whether remedies so provided under the RERA Act to an allottee is the only and exclusive modality to raise a grievance, and where the provisions of the RERA Act bar consider the grievance of an allottee by other fora. On the strength of the law so declared, Section 79 of the RERA Act does not in any way bar the commission or forum under the provisions of the CP Act to entertain any complaint. It is true that some special authorities are created under the RERA Act for the regulation and promotion of the real estate sector. Issues concerning a registered project are specifically entrusted to functions under the RERA. The present purpose go by the purport of Section 18 of the RERA Act. It gives a right without prejudice to any other remedy available in effect, such as the remedy is acknowledged and saved, subject always to the applicability of Section 17. Then kindly see, my lord, we may now consider the effect of the registration of the project under the RERA Act. In the present case, the apartments were booked by the complainants in 2011-2012. Builder buyer agreements were entered into in November 2013. As promised, the construction should have been completed in 42 months. Period had expired well before the project was registered under the provisions of the RERA Act. Merely because the registration under the RERA Act is valid till 31st December 2020 does not mean that the entitlement of the allottees concerned to maintain an action stands deferred. So, my lord, during that period also, it is relevant to note that even for the purpose of Section 18, the period has to be reckoned in terms of the agreement and not the registration. Condition 10 of the letter of 2017 also entails an allottee in the same fashion. Therefore, the entitlement of the complainant must be considered in the light of the terms of the builder buyer agreement and was rightly dealt with the commission. Now, 20. It is clear, in view of the clear and categorical principles laid down in imperial structure, the submission made on behalf of the developer have to be rejected. This position has also been affirmed in EDO Grace. In EDO Grace, this court had an occasion to consider the question as to whether the provisions of the RERA must be given primacy over the Consumer Protection Act. After re-examining the provisions of the Consumer Protection Act and the RERA Act and following the principles laid down in Imperial, the court held as under. But after considering, here the statement of objects and reasons have been considered. In coming to its conclusion, 21, kindly comes 21. In coming to its conclusion, the three-judge bench relied on the judgment of the Imperial, which clarified and declared that Section 18 imposed a liability on the promoter to return the amount with interest to the allottees upon its failure to give possession in accordance with the terms of the agreement. The expression without prejudice to any other remedy available in Section 18 of RERA Act is very important, while noting the same court observed as under. In a 42, I was just going to place video. In a recent judgment delivered by this court in Imperial, it was held that remedies under the Consumer Protection Act were in addition to the remedies available under special statute. The absence of a bar under Section 79 of the RERA Act to the initiation of proceedings before a fora, which is not a civil court, read with Section 18 of the RERA Act makes the position clear. Section 18 of the RERA Act specifies that the remedies are without prejudice to any other remedy available. We place reliance on this judgment. From the two decisions referred above, it is crystal clear that the Consumer and the RERA Act neither exclude nor contradict each other. In fact, this court has held when there are concurrent remedies operating independently without primacy. When statutes provisions judicial remedies fall for construction, choice of interpretive outcome should also depend on the constitutional duty to create effective judicial remedies in furtherance to access of justice. Now, my lord, may I just place EDO, my lord? This is 2021, 3 Supreme Court cases, 241. And it kindly comes to Malad that running page 274 Malad on the top left hand Malad. Para 36. Three judges bench Malad. But I just wanted to show this Malad. Your Lordship will kindly see whether primacy to be given in RERA over the Consumer Protection Act. Malad, your Lordship has found that Malad. Yes, sir, 36. I just want to show Malad, if your Lordship comes to the next page. kindly see section 3 of the Consumer Act and kindly compares it with section 88 of the RERA Act. The provisions of this act shall be in addition to and not in derogation of provisions of any other law for the time being. Same language. And then the Supreme Court has considered all the sections will kindly see here reference has been drawn to the Thirumurungan Corporation judgment at page 275, and then National Seeds Corporation 36.3. One only paragraph from that judgment as set out here at page 276, if your lordship kindly comes. The remedy of arbitration, 66, the last paragraph there quoted. The remedy of arbitration is not the only remedy available to a grower. Rather, it is an optional remedy. He can either seek reference to an arbitrator or file a complaint under the Consumer Protection Act. If the grower opts for the remedy of arbitration, it may be possible to say that he cannot subsequently file a complaint under the Consumer Protection Act. However, if he chooses to file a complaint in the first instance before the competent consumer forum, then he cannot be denied relief by invoking section 8 of the Arbitration Conciliation Act. Moreover, the plain language of section 3 makes it clear that the remedy available in that act is in addition and not in derogation of the provisions of any other law for the time being in force. Now, my lord kindly comes to paragraph 37 at page 277. Then my lord kindly sees 37 will now consider provisions of RERA Act and goes on to consider my lord provisions of the RERA Act. Paragraph 37.1, again the Supreme Court notes my lord, that it is without prejudice to any other remedy available. Then my lord kindly sees 37.2, section 71 of the RERA Act empowers RERA authority to determine compensation payable under sections 12, 14, 18 and 19 of the Act. The proviso section 17 provides the consumer the right to withdraw its complaint before the consumer forum in respect of matters covered under such and such and file the same before it. Then my lord kindly comes to next page 37.3, my lord. That's why I read my lord section 79 and then section 88 at 37.4. Now my lord kindly sees 37.5. An allotee may elect or opt for one out of the remedies provided by law for redressal of its injury or grievance. An election of remedies arises when two concurrent remedies are available and the aggrieved party chooses to exercise one, in which event he loses the right to simultaneously exercise the other for the same cause of action. And then the doctrine of election has been dealt with, my lord. Therefore, my lord, it was found that, my lord, it is in addition and doctrine of election would apply in such cases, my lord, vis-a-vis, my lord, an arbitration and the RERA, where, my lord, it was being considered arbitration and the Consumer Protection Act. Similar, my lord, here also it has been so found that because of section 88 and section 18, my lord, the court has jurisdiction. My lord, now, my lord, this is a single bench, though, of the Guwahati High Court, kindly see, Well, this is 2024 SCC online Guwahati 751. Yes. Kindly have a look at paragraph 27. Now, kindly see 26 onwards. But internal page would be page 9, Malad, in the prints of SCC, Malad, if you logic kindly see on the top left hand corner. In case of AP State Financial Corporation, the Supreme Court has held that the doctrine of election clearly suggests when two remedies are available for the same relief, the party to whom the said remedies are available has the option to elect either of them. But that doctrine would not apply to cases where the ambit and scope of the two remedies are actually different. To hold otherwise may lead to injustice and inconsistent results. My first submission, Malad, the remedies are not the same. And I have not asked for penalty punishment. I have not asked for that. Then kindly see 27, as can be seen from the above section 79 of the Red Act, bars the invocation of the jurisdiction of civil court. However, an arbitral tribunal is not a civil court, though it is a judicial authority. In the case of Molloy Kumar Ganguly, the discussion is on civil court. And then, Malad, kindly straight away comes to Malad para 32. That it has dealt with that earlier. Para 32, 33, 34, the same paragraphs which Mr. Shah has relied upon have been dealt with. Then Malad straight away comes to para 37. On applying the fourfold test, Malad, that is internal page 12, Malad. To whether the subject matter of this writ petition is arbitrable or not, this court finds that the fourth test is to the facts of the case, and as such does not bar the subject matter in dispute in this case from being arbitrable. As can be seen in the various judgments, Supreme Court, arbitration is not the only remedy available to a consumer, and they can seek reference to arbitration or file complaint under the Consumer Protection Act. The judgments of the Delhi High Court and Patna High Court are more specific to the issue to be decided in the present case. That the Arbitration Act is not inconsistent or in derogation of the RERA Act. Thus, arbitration can be invoked by a party in spite of the availability of the alternative remedy provided under the provisions of the RERA Act. Just one more judgment, and I rest my case, This is 2022 SCC Online Delhi 4717. And there's a heavy discussion on the RERA and the Arbitration Act, in this judgment, and straightaway taking lordship to the conclusion, para 32. From the foregoing, there is no doubt in the mind. Sorry, it's internal page 12, sorry, on the top, 12. Yeah. 32. From the foregoing, there is no doubt in the mind of this court that giving a purposive interpretation to sections 79, 88, and 89 of the RERA Act, there is no bar under the RERA Act from application of concurrent remedy under the Arbitration Conciliation Act. And thus, there is no clash between the provisions of the RERA Act and the Arbitration Conciliation Act, as the remedy is available under former in addition to and not in supersession of the remedies available under the Arbitration Conciliation Act. Then, Malad, kindly just have a look at paragraph 40. From the foregoing to thus clear, the remedy available in the Arbitration Act is in addition to the remedies available under the other special statute. The alternative remedy is not a part to the entering of petition, but once elected, then the other remedy will not lie in respect of the same dispute. That's why, at the very beginning of this argument, I had said that I am not a party to RERA. I have not filed anything in RERA. So therefore, these judgments, clearly indicate, and after reading of sections 79, 88 and 89, arbitration is an addition, not in derogation. RERA cannot pass any orders of specific performance of the main conveyance. It only provides for filing complaint for non-allotment or non-completion. And for that, there are remedies of fines and other things. So, therefore, that is my submission. And, I had already shown the order of the learned arbitral tribunal, very well reasoned. And there is no dispute that he also feels that there should be a surveyor to be appointed under 17C. Also, these are my submissions. If your lordship has any.
What will you achieve with the appointment of the surveyor?
Yes. May I just take your lordship to the order? Just see that. Page 30 of the state petition.
But that issue is already there before RERA.
Sorry,
RERA had already.
No,
passed an order
RERA
earlier.
issue is a bit of a different issue altogether.
No, as far as maybe. I'm
The
not.
the
The directions
order-
which have been passed by the RERA
Malat.
is also to get the entire measurement done.
RERA orders are far more than what has been ordered here. Maybe. Yes. But the dispute which I have raised, is vis-a-vis to only my community. And next question is, whether in my arbitration,
Not only your common area of the entire building.
community allotted to me, the proportion of the entire building, obviously, I have a proportionate right in the community.
Correct.
That is what I want.
Every flat owner would have a proportion.
Yes, definitely, there's no dispute about that. I am only asking that part of common area or areas which were given to me under my schedule, has it been violated or has it not been violated? If it's been violated, I'm asking for a specific performance. That is what I want. Now, it kindly comes to the order, section 17, if your lordship kindly appreciates, is white powers, These powers are to be, undertaken if and when I make out that case. My case is, when kindly comes. Kindly comes to 11A, that's at page 54. Prayer A, B, and D. I also failed to point out one small observation by the learned arbitrator. Kindly see page 54J.
For that, there has to be a specific application for that.
My application was there.
Under 20.
I said I need an expert. Either section 17 or whatever. Now, kindly appreciates. In section 25, with humility, I say, section 25 gives the suo motu right to the arbitrator also. Kindly see, that's what I wanted to read out to your lordship, other than 17, he also felt that way. That is why he gave that observation. But kindly see 25, sorry, 26.
'26 is evidence collection.
Unless otherwise agreed by the parties, The 27 is the evidence collection by the court, my lord. This is unless otherwise agreed by the parties, the arbitral tribunal may report to it on specific issues to be determined by the arbitral tribunal. And what is the issue that has been fixed? Whether the construction areas have been given in terms of the lease deed or not. But the tribunal felt that yes, there is a dispute, I need to find out. Well, may I just then read the conclusions? Well, I think that will be better for your lordship, and for me also. There is no, it starts from 51, page 51. There is no dispute that the plan, conclusion, sorry, page 51. There is no dispute that the plan initially sanctioned in 2016 and revised by another plan sanctioned in 2018. Also no dispute that the claimants applicants the subleases of the lease granted by the respondent with power to sublease. Question dispute that appears from the pleadings of the claimants and applicants that the initial plan whereby 80 flats sanctioned were modified by construction of 3 additional flats since been let out to third parties and construction made in E-deck level. These constructions, according to the claimants applicants, have been made encroaching upon the common areas described in the details in third schedule of the sublease granted in favor of the claimants and applicants. The action of the respondent making all such construction post execution of sublease granted in favor of the claimants constitute clear violation breach of the contractual terms and conditions of the sublease. Over and above the additional construction claimed to have been done by the respondent, a modified sanction plan violates the provisions of RERA by section 14.2, which provides the consent of 2/3 majority of allottees to be obtained from before the original sanction plan is modified and the additional construction are evident from Xerox copies and the others showing construction in the void. Respondent's stand is that additional construction of flats and construction in E-deck level have been done in accordance with the revised sanction plan. The claimants applicants, all allottees concerned were aware and are always aware of such additional construction done under the revised sanction plan. Such construction pursuant to the revised sanction plan does not attract RERA, which came into force post such revised sanction plan. This is their submission. Therefore, the consent of 2/3 is not necessary. The core issue in the reference is whether the construction additional flats. I have read this already, to your lordship, the issue has been identified. And D also I have read, F. In the backdrop, I have also read this one. Well, the is G. The respondent submission that order prayed for in the application of past will affect the third parties who are in possession or occupation of the area of additional construction not parties to this reference is devoid of any substance. The opinion of the tribunal order of service prayed for would not in any way affect the third party's possession or right in any manner whatsoever. The prayer for service based on the rights and obligations provided in the deed of sublease. Strict observance thereof is pressed in the reference. The principles raised on additional cited by the respondent noted in paragraph 7F above are settled principles, but in the facts and circumstances of the case, submission of claimant in this regard, tribunal finds the whole that those decisions have no manner of application. The respondent's submission that the claimant is seeking to fish out evidence and reliance on order 39 rule 7 suppose there was devoid of any substance, the release paid for in this application cannot be termed as fishing out evidence by the claimant. The decision mentioned in paragraph 7G above thus have no manner of application in this case. Under section 25 and 26 is vested with power to appoint one or more experts for report on specific issues to be determined. This in this case can be granted by the tribunal. Now, your lordship has seen 17C also, even for collecting evidence. That's the difference between order 39 rule 1 and 2, and this specifies about inspection taking evidence in 17, and that is what I wanted. And again I say, the power of the tribunal under section 17, unless, with humility, I say, kindly does not take famous, unless it is beyond the agreement. The orders are beyond the agreement. Then, I could have understood, yes, it is a perversity. But he is dealing with what is intra the jurisdiction of the arbitral tribunal under the agreement. Today, my lord, your question fell from your lordship, my lord. May I try and answer that, my lord? Yeah. What will I achieve? And it fell from your lordship. Let us say today RERA is not there for the time. The RERA order is also not for the time being. But we will have an order where both the parties will be at the local. That's the direction. The inspection will be taken before both the parties. And that will be before the arbitral tribunal. That is a part of the tribunal's record. Now, Malak, with humility, I say, Malak, they say that they have got, or rather there is an order of KMC. I'm not privy to that. I'm not privy to that. The tribunal is also not privy to that unless it is brought in as an evidence by my learned friend's client. So I'll be relying on a third party dispute, if I can say that, Malak, for my personal grievance against my learned friend's client vis-a-vis the agreement, the conveyance deed. And Malak, today, Malak, that they are saying that it has been undertaken, Malak. I was not a party there. I did not go there also. Today, Malak, they have not placed the entire pleadings before the tribunal that this is what was going there. What is the complaint, Malak? It involves a lot of things, Malak. And Malak, the RERA can take actions otherwise. This agreement.
Scope is different.
Scope is different. So therefore, Malak, there should be something, Malak, which will prejudice. I don't understand where the prejudice coming from. Malak, if that comes, either I will rely on it or my learned friend will rely on it. There will be exceptions. They will become a part of the record, and whatever way we'll rely on it, or dissociate the arbitrator from relying on it. I don't know which side that survey report will go, but that will be within the domain. Therefore, I say, Malad, again, Malad, then this evidence part, Malad, which I would obviously rely upon if it is in my favor. Then, Malad, it will be a Malad, I will be left remediless because of another collateral proceeding. Lordship wants to see, Malad, I can show. Malad, it would be so much evident. Malad, I can open the plans, Malad, which are shown before the tribunal, Malad. Why the tribunal came to such a conclusion, Malad? And I can show the two plans, Malad. Huge plans.
আমি এটা জানতাম না বলে নয়তো আমি দিয়ে দিতে পারতাম হাতে।
It's evident.
আরে একটাই কপালে এসে গেছে
It
আমার।
was left suddenly.
ঠিক আছে স্যার।
আরো আসুক।
But what they allege,
তো এখানে কপি দিলে আর পাঠানোর দরকার হবে না।
না ওখানে পাঠিয়ে
The
এখানে
common
soft
area.
copy দিলেই
স্যার
হবে।
এই
within
পাশেই আছে
This
মানে
is the
ওদের
only
যে
show.
শিপিং
of
কর্পোরেশন
the
আছে
survey,
মেন
within outside.
আপনাকে এখানে বা সফট কপি
তাহলে তো আমি জানতাম না বলে
That
সব
is the scope of this Malad
এটা
survey.
হয়ে যাওয়ার পরে
Because they have
আরো
raised
আসবে
this
ওই মধ্যে
defense.
করা যাবে।
আচ্ছা আর
It is beyond the common area.
কথা বলা দরকার নেই
seen
তো
that.
তোমার দিদির সাথে।
না,
That's what the
No, no,
arbitrator is
no,
all about. Malad, they could have taken a point
ঠিক আছে।
that look, there were 3 points. And I'm sorry, Malad, just gives you one more minute. That we were entitled to it under the sanction plan. Fair enough. We were allowed estoppel, waiver, good. But this becomes a question of fact. They say it's not a part of the common area. It was beyond the part of the common area.
জি স্যার।
And that is why the survey, Malad. Malad, those are my submissions, Malad. I'm sorry, Malad, it took a bit of time, Malad, but
My lord, I will try not to be so verbose and elaborate, my lord, keep it within the short conspectus. I've run out of pages, my lord, of all that Mr. Ray has said. My lord, the fundamental issue, my lord, which I had urged for your lordship's very kind consideration, is whether the dispute is non-arbitrable. If the dispute is non-arbitrable, then that was an issue which the arbitrator had to decide at the threshold. If he has not decided that at the threshold, my lord, then the order is per se bad. Because if he doesn't have the jurisdiction, then, my lord, he can't proceed, my lord, an inch further according to us. That is, my lord, our respectful submission. Now, my lord, Mr. Ray tries to answer, my lord, this question of, my lord, jurisdiction being vested in the arbitrator by relying on this decision, my lord, where he says that, my lord, taking the example of Consumer Protection Act, is they both can run parallelly. So, you see, it's not that there is any absolute bar. And also, my lord, he relies upon that decision, my lord, of the Delhi High Court, which says, my lord, that, my lord, it is, my lord, not a specific bar. Now, my lord, first of all, my lord, he has, my lord, relied upon, my lord, paragraph 55 of Vidya Rolia, which is a judgment of 3 judges of the Honorable Supreme Court, and would therefore, my lord, obviously have primacy. Now, my lord, Vidya Rolia, my lord, I will not again, my lord, trouble your lordship with it. I have given your lordship the paragraph numbers. There is a categoric, my lord, or my lord, at least it is our submission, there is a categoric, my lord, affirmation of the fact that if there is a special statute created for certain special purposes, then the subject matter of those statutes cannot be referred to arbitration. Now, my lord, he has, my lord, relied upon section paragraph 55 of the judgment, which says exactly the same thing.
That issue is not here. You have all consented to the arbitration. It has been sent by consent. The arbitrator.
Yes, I am coming to that, my lord. That, my lord, is answered in half a second, my lord. I'll come to that. Now, my lord, only this, my lord, very well, my lord, may I go there first? My lord, kindly take section 16, subsection 2. The plea, I'm sorry, has your lordship got it? A plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. However, a party shall not be precluded from raising such a plea merely because he has appointed or participated in the appointment of the arbitrator. So, my lord, and my lord, it is, my lord, trite law that, my lord, whether, my lord, it is arbitrable or not arbitrable, my lord, is not, my lord, gone into, my lord, at the section 11 stage. If you want to challenge, my lord, the jurisdiction of the arbitrator, you want to challenge the arbitrability, that happens only, my lord, under section 16 before the arbitrator himself. So, my lord, I was a little surprised.
All your arguments regarding arbitrability is based on the fact that there is a RERA provision which covers it.
Two, my lord, RERA and KMC.
KMC, right? But as far as the inspection is concerned, it is something which is just a preliminary stage. The decision still not been arrived whether it is arbitrable, not arbitrable. This is just the fact finding which is being done by the arbitrator at this stage.
Tayyab Bhai is the answer, my lord. Once a question of maintainability is raised, unless, my lord, there is a pressing need for an injunction.
In your statement of defense, you have raised the
Yes,
issue of
yes,
maintainability.
yes, of course. I am duty bound to show that to your lordship. My lord, kindly just permit me to, my lord, get over this point, my lord, of on the law. Then, my lord, I'll come to the, my lord, small factual aspects, my lord, which require your lordship's attention. So, my lord, my contention was that it is not arbitrable. He says that it is arbitrable and he relies on 2 decisions. My lord, let me quickly get through those decisions. Now, my lord, my friend has relied upon 2022 SEC Online Delhi 4717. My lord, kindly have paragraph 19, where, my lord, Vidya Rolia has dealt with. My lord, I was a little taken aback, my lord, when he read it out. No, because, my lord, Vidya Rolia I thought was very clear. Now, my lord, this is a matter where, my lord, there was an allotment of a flat in favor of, my lord, the petitioner. That allotment was cancelled. He wanted his money back. And, my lord, it was therefore held that this is the claim relating to return of money. Does not really have anything to do with, my lord, the construction, my lord, whether it is correct, incorrect, space, allocation, nothing. Kindly permit me to read, my lord, paragraph 19. The dispute herein does not fall into the category of cases which have been recognized as non-arbitrable in Booz Allen and in Booz Allen. The fourfold test of non-arbitrability laid down in Vidya Drolia remains unfulfilled in the facts of the instant case. The claim for refund of money arises from cancellation of allotment under the flat buyer's agreement and thus relate to rights in personam which are amenable to arbitration. No issue in rem has been put forth by either side. This was the issue here. He applied for a flat, it was cancelled, he wanted his money back, they're not giving him back his money. For that, my lord, RERA will not come into the picture, quite rightly so. Now, my lord, let us now, my lord, juxtapose this with the Consumer Protection Act. My lord, same thing, my lord, absolutely the same ratio. My lord, under the Consumer Protection Act, my lord, you are asking for an entirely different relief. Now, my lord, I have all, my lord, if required, my lord, if your lordship requires a note, I'll put it in my note. I won't trouble your lordship with the facts again. My lord, the issue before the RERA, and I say this with a sense of responsibility, the issue before the RERA and the issue before the arbitrator are, my lord, completely, my lord, similar. Over there also E-block, here also E-block. Over there also you've constructed a flat, here also you've constructed a flat. Over there also the construction of the flat is encroached into the E-block, here also the same thing. It is absolutely identical. Now, my lord, even if it is not identical, if there are, my lord, issues which are overlapping, RERA is bigger, this is a subset of, my lord, the RERA proceeding. Even then, my lord, the issue is not that. The issue is, my lord, whether the dispute, my lord, envisaged or the dispute referred to arbitration, my lord, would come within RERA. My lord, in this regard, my lord, kindly, my lord, take section 34 once, 34F of RERA. Kindly see, my lord, functions of the authority. This is the duty of the RERA. Kindly come to, my lord, amongst others, my lord, F, to ensure compliance of the obligations cast upon the promoters, the allottees of the real estate agents under the Act. So, my lord, any obligation cast upon the promoter, if the promoter, my lord, does not, my lord, fulfill that obligation, RERA is attracted under 34F. Now, if he is saying that, my lord, I was supposed to be given so much area and block E and you didn't give it to me, then that's, my lord, an unfulfilled obligation. Squarely, my lord, RERA would apply. And if, my lord, RERA applies, then, my lord, my learned friends, my lord, cannot, my lord, keep setting, my lord, courts and tribunals and arbitrators against RERA and, my lord, courts against each other. My lord, I will show to your lordship, my lord, that this entire proceeding, my lord, is a complete witch hunt. Because, my lord, I don't, my lord, have the documents right now, but, my lord, on each day of the inspection, my lord, RERA directed an inspection that has been carried out. So there is already an inspection report, my lord, which is on record. And Mr. Karnani was there present, my lord, during each day of the inspection. But that's happened, my lord, in between, my lord, between, my lord, the last hearing. But it's been carried out. It's happened. But, my lord, I don't want to take advantage of that.
The judgment records contrary to this.
Yes, because at that time
It had not been.
it had not happened, my lord. Of course. At that time it had not happened. So, my lord, my first submission in my lord, rebuttal to, my lord, what Mr. Ray has said, my lord, is that, my lord, if it is non-arbitrable, the matter ends there. Now you want to say it is arbitrable by relying on these two judgments. This judgment, my lord, of the Delhi High Court is clearly distinguishable. It related to return of money. And, my lord, so far as, my lord, Consumer Protection Act is also concerned, my lord, if the Consumer Protection Act is asking for an in rem relief, here the relief is in rem. The enjoyment of Block E is not his exclusive domain. My lord, he is not saying that a tap in my particular flat is not working. Or that, my lord, a particular facility to be given. You were supposed to make French windows in my flat. Or, my lord, instead of Jaguar, you've used some lower variety brand. That's not his complaint. His complaint is not specifically related to his flat. I don't know, my lord, then, my lord, under what stretch of imagination he comes before your lordship to contend, my lord, that his action is an action in personam. It is completely an action in rem. His, my lord, his twofold grievance is number one, you constructed a penthouse on an area you should not constructed the penthouse inside his house or on his garden. Common area by definition is, my lord, not exclusively his. He can't say, my lord, it's in personam, right in personam violated. And if, my lord, in the eve deck, my lord, instead of 1,000 square feet, there is 990 square feet, 10 square feet less, then he also cannot say, my lord, it is this thing. That's number one. The second aspect of the matter, my lord, again, my lord, I'm a little bewildered because he keeps saying that, my lord, he wants to ask for specific performance. That's how it becomes maintainable. My lord, kindly see, my lord, his, my lord, the power, my lord, which I said in section 34, my lord, is also, my lord, there in section 38. I am not, my lord, bothering your lordship, my lord, with that. Now, my lord, the SOC, my lord, captures, my lord, the prayers that he's made before the arbitrator. He has also already read it out, my lord. Your lordship will find that, my lord, in page 115.
100.
There is no prayer for specific performance. There is not one pleading. And, my lord, while Mr. Ray was engaging your lordship, my lord, in his submission, my lord, we checked. Not one prayer, not one pleading for specific performance, my lord, and he is, my lord, held forth on specific performance all this while. Now, my lord, what is his prayer? His prayer is, my lord, declaration that the construction undertaken by the respondents is unauthorized. That's exactly, my lord, what, my lord, the RERA is there for. Completely overlapping. Kindly see, my lord, his prayers, my lord, this is very important. What is his prayer, my lord, in his statement of claim? First is declaration that the construction undertaken by the respondent in Schedule B is unauthorized and illegal, being violative of the indenture of sublease, so and so. My lord, this, my lord, if my lord, the RERA is not there, my lord, to look into this, my lord, I don't know what the RERA is there for. Secondly, my lord, his second prayer is order declaring the respondents is invading the right to enjoyment property, invasion in such compensation money could. This is, my lord, covering damages. But again, my lord, not a single prayer for damage. So, my lord, neither does he make a prayer, my lord, for, my lord, specific performance, nor does he make any prayer for damages. But his entire, my lord, argument, my lord, has been based on, my lord, these two limbs. My lord, I am entitled to specific performance, I am entitled. That is not what you're entitled to. That is not your statement of claim. You cannot invent as you go along. That is not your case. That is not what you went to the arbitrator for. You went to the arbitrator exclusively for redressal with regard to certain grievances which you have, which are completely within the domain of the KMC Act, my lord, and the RERA Act. Next, my lord. My lord, and my lord, very, very, my lord, interestingly, my lord, the RERA, my lord, the RERA also has the power to award damages under section 71 for violation of section 14. So, my lord, that power is also there in the RERA. Be that as it may, my lord. Now, my lord, kindly see. My lord, permit me to show your lordship, my lord, one clause, my lord, of his mother document, his, my lord, indenture of sublease. Show me that, where he is. My lord, it's there in the supplementary affidavit, first supplementary affidavit. My lord, page 693.
Yeah.
Completely, my lord, in my very respectful submission, without meaning any disrespect to my friend, my lord, completely vexatious litigation. My lord, my learned friend's sublease, on the basis of which he acquired this flat, starts at page 689. If your lordship, my lord, kindly has Yes, my lord, paragraph I. The sublessor has got approved and sanctioned from the Kolkata Municipal Corporation with a memo dated 6 June 2011 building plan. This is the first building plan, 6 June 2011, being plan number so and so, for the construction of the said complex on the scheduled property, and further received revised sanction plan being number so and so dated 5th November 2018. When he bought this property, when he bought his flat,
Under this revised plan, the construction is taking place.
yes, under this revised plan, the construction, my lord, let me, my lord, break it down further for your lordship's benefit. Under this revised plan, which is mentioned in his deed of conveyance, the construction has taken place. In spite of that, my lord, he was party to, my lord, a complaint made by the KMC. The KMC came, inspected, and said there is no problem. It's according to the revised sanction plan. And after this, my lord, this is, my lord, what I am being put through. Now, my lord, so, my lord, your lordship sees this entire, my lord, hullabaloo, my lord, as to, my lord, the promoter, my lord, having dishonestly encroached and grabbed, my lord, his common area, is, my lord, completely, my lord, belied, my lord, from his document, it's from his own document itself. Why did you buy it? Did you not know there was the sanction plan? What is your explanation for that? Your deed of conveyance, your deed of sublease mentions the sanction plan, and now you're over here in every forum challenging, saying that this is not according. My lord, thereafter, my lord, I'll just, my lord, quickly move on. Now, my lord, he says, his first, my lord, now very quickly, my lord, I am not a party to RERA proceeding. You don't have to be a party, my friend. Number one is the association of which you're a member, which you cannot deny. The president, prime minister, general secretary, speaker, everybody, my lord, has gone before the RERA. Now, my lord, today, my learned friend, my lord, says that, my lord, each of their complaints is the same. Now, my lord, if my lord, he says he has a right in personam, they also have a right in personam. So how could they have approached the RERA? I don't understand. So, my lord, he and, my lord, the other flat owners who have approached the RERA stand on an absolutely identical footing. They are members of the same association. When, my lord, the RERA inspection, my lord, survey was taking place, he was personally present, my lord, on each day that the survey took place. Of course, those survey records are with, my lord, RERA. Now, my lord, therefore, my lord, kindly see, his being a party before RERA or not being a party is completely irrelevant. Oh, sir, I don't want to go into that. I don't want to go into that. My lord, twofold reply to this. Number one is that by saying that I am not a party to RERA, you don't overcome the bar of non-arbitrability. Number one. Number two is that even if you're not before the RERA, the issue is before the RERA. And the RERA is already, my lord, in season of the matter. And, my lord, now, my lord, kindly permit me to show you that I had raised, my lord, this issue of maintainability.
That's what I want.
Yes, my lord. May I just, my lord, kindly have. Huh? Yes, my lord, in the first supplementary affidavit, which is, my lord, before your lordship, 797, my lord, is my affidavit in opposition to his section 17 application. একটু দিন ফার্স্ট অ্যাফিডেভিটটা এক্ষুনি যেটা দেখাচ্ছিলেন my lord, 797 is my affidavit in opposition to his section 7. Kindly first come to, my lord, paragraph 5. Identical reliefs have been claimed before the Real Estate Regulatory Authority by the allottees. The applicants are guilty of forum shopping. The complaint filed before the Real Estate Regulatory Authority contains prayers which are similar to the reliefs claimed in the present application. Then, my lord, kindly come to paragraph 8. The application is therefore misconceived and not maintainable. Now, my lord, yes, paragraph 7 also. The application is an abuse of process. Prayers made in the application at section 9, so already granted. My lord, anyway. So, my lord, paragraph 5, I have specifically, my lord, raised the radar flag. Then, my lord, paragraph 8, I have said, my lord, that it is not maintainable. And, my lord, kindly see, my lord, in the impugned order, my lord, at page 50, the impugned order at page 50, my lord, paragraph G for Ganga. It is submitted that prayers A and B and so, my lord, kindly see, cannot be passed in the absence of the third party. It is submitted that in paragraph 211 to 21 of the petition, claimants and applicants have admitted the construction and alleged that those are wrongful, referring to paragraphs 14, 31 and 32 of the REDA. Well, this should perhaps be, my lord, paragraphs, sections 14, 31 and 32 of the REDA. It is submitted that it is a special statute and the authority has wide powers. Now, my lord, this is noticed in the judgment, and thereafter, my lord, there is complete silence. So, my lord, this, my lord, issue of maintainability is noticed in the judgment, which is, my lord, proof of the fact, my lord, that, my lord, this was argued and it's not been, my lord, answered. So, my lord, your lordship will find that it is perhaps not entirely correct. Yes, my lord. Even, my lord, in page 37, my lord, submissions with regard to REDA, my lord, are recorded. Kindly just take, my lord, page 37.
C.
My lord, B.
C.
B, my lord. B for Bombay, page 37. Oh, C. B or beta, that right? B and C.
Yes.
In the absence of the Kolkata Municipal Corporation, none of the reliefs claimed here can be given. Because, my lord, we have taken, my lord, the sanction from KMC. Then C. Identical reliefs have been claimed before REDA. D. Present application is an abuse. Prayers made under section 9 so and so granted by order of a learned district judge so and so. Then, my lord, E. Misconceived, not maintainable, liable to be dismissed. So, my lord, these are, my lord, the fact that I had, my lord, raised the flag of KMC, raised the flag of REDA, my lord, is recorded in the body of the order. So, my lord, one way or the other, my lord, win or lose, my lord, it has to be decided. Now, my lord, so after saying, my lord, that he is not a party to REDA, my lord, and therefore, my lord, it becomes arbitrable, my lord, he moves on to say that he has an arbitration contract and therefore, my lord, it's an action in rem. My lord, this is exactly, my lord, the point. That you may have an arbitration contract, but that doesn't justify. If you have an arbitration contract to murder somebody, it doesn't become legal. So, my lord, these are special statutes, my lord, which have to be, my lord, dealt with in special courts. Then, my lord, next submission is, my lord, section 16 not filed. My lord, in the affidavit in opposition, I specifically take this point. It's not answered, my lord. My learned friend says that, my lord, section 16, my lord, has to be filed. And, my lord, I had shown your lordship, my lord, section 16, subsection 5. Kindly take this once, my lord. The arbitral tribunal shall decide on a plea referred to in subsection 2. This is, my lord, on jurisdiction. Or subsection 3. And where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceeding. So, my lord, till such time that he decides on his jurisdiction, he is stopped from proceeding. My lord, and of course, my lord, section 16 starts with, my lord, the suo motu powers of the tribunal to rule on its own jurisdiction. That's the first line of section 16, my lord. The arbitral tribunal may rule on its own jurisdiction. So, my lord, whether anybody raises, does not raise, my lord, the tribunal, my lord, could have gone into it. Next, my lord, moving on quickly, my lord. my lord, he invites your lordship's attention. My lord, yes. My lord, sections 88 and 89, my lord, seem to have caused a great deal of confusion in my friend's mind, my lord. He says, my lord, because of sections 88 and 89, he has the power to, my lord, go to arbitration. My lord, my lord, kindly don't take the section once again. My lord, this is not something your lordship should be bothered with so much. Application of other laws not barred. Now, my lord, I don't know, my lord, but my lord, the other law, my lord, is specifically barring this. This does not, my lord, the application of other laws. Now, my lord, arbitration, my lord, is really, my lord, of course, there is an arbitration act. But, my lord, it is, my lord, just like, my lord, providing a forum. Like, my lord, the Civil Procedure Code, my lord, provides the forum. It, my lord, decides the forum, it decides the procedure. It doesn't, my lord, contain the substantive law. Which my friend, if my friend said that, my lord, I am doing something, my lord, in violation of another act, it's, my lord, to add to that, then of course. And, my lord, here when the Supreme Court has already held, my lord, section 88 cannot be given, my lord, another interpretation. Section 88, my lord, cannot be relied upon when the Supreme Court has specifically held in this regard. And, my lord, section 89 is completely in my favor. Act to have overriding effect. RERA Act to have overriding effect. So, my lord, under section 34F, under section 38, my lord, any violation by the promoter, my lord, I am answerable to RERA. That's why, my lord, before I start any project, my lord, I have to register myself with the RERA. Then, my lord, the next. The next point is, my lord, that, my lord, he is no longer at the allocation stage. He has got a conveyance. And therefore, he is out of RERA. My lord, with a conveyance, he is saying that, my lord, there is a violation of his common right in the building. If it is a violation, my lord, of his common rights, then whether he is an LOT or, my lord, he has already got a conveyance of his, my lord, I don't see, my lord, where the bar is, because, my lord, it would still, my lord, be before the RERA. Have you got the not got the And, my lord, the fact that I retain, my lord, jurisdiction, my lord, is, my lord, evident from section 11, subsection 4A, which says, my lord, till the CC is issued, my lord, the chopping block, my lord, contains the head of the promoter till the CC is issued. And here, my lord, is only partial completion certificate till date. So, my lord, post, and, my lord, I was wondering, my lord, if it is. So, my lord, all the others are also, my lord, post allocation. Everybody has a conveyance. So, my lord, it's a good point for me to argue, my lord, before the RERA, my lord, and get that it's now no longer RERA, my lord, is applicable. My lord, my learned friend, my lord, has also, my lord, distinguished, my lord, to try, my lord, Vidya, Droli and other things, my lord, I am not troubling your lordships with them. And my lord, only one last thing, my lord, the order of the DB by which, my lord, the arbitrator was appointed. My lord, he appoints the order, my lord. I'll just give you, lordship, the page number, paragraph 7 of the DB order. My lord, it is needless to mention that in the event it is ultimately found that such construction was beyond the agreement or the sanction plan or modified sanction plan, as the case may be, the petitioner shall be entitled to seek such reliefs as he may be advised in the arbitration proceedings or before any other appropriate forum. The order passed by the learned trial court is modified accordingly. The, my lord, order passed in the section 9. So, my lord, my lord, it is not that, my lord, that the DB, my lord, had appointed and said that you can't travel beyond the four corners of this and you must go to the arbitrator. But the question of arbitrability is always decided under section 16. Huh? Oh, my lord, one last thing, my lord. On this, my lord, let me assume, my lord, I gave consent. I give consent, my lord, to a seat of arbitration in Honolulu. My lord, can, my lord, anybody, my lord, any court, my lord, be conferred jurisdiction by consent of the parties? That's, my lord, ABC laminate. My lord, jurisdiction can't be, my lord, conferred by consent, my lord. Now, these are my respective submissions.
So a few factual aspects. I
What
just
would
pointed
be?
very quickly, my lord, because he has taken these points in his reply, my lord, weren't taken in his opening submissions. But one thing, my lord, I'll just point out, my lord, statement of defense, my lord, at page 118, my lord, kindly keeps note, my lord, your lordship will not find the issue of arbitrability have been taken. Arbitrability has not been taken, my lord. I might not have relief which I did not get.
The statement of defense has been filed after the statement of statement, my lord, affidavit in opposition to section 7. Now, I've found that out.
23rd June, 20th June, and the statement of defense was filed 20th of May.
After that,
My lord, in none of the statement of defense as well as the statement, the affidavit in opposition, the question of arbitrability has not been taken, but maintainability is a different thing altogether. My lord, why I'm saying this, my lord, my learned friend makes it a point to refer to 16, 1, 2, 3, 4, 5. My lord, I'm asking myself, where is this question taken? Where has this question been taken?
The statement of defense.
My learned friend has referred to that paragraph where Mr. Chaudhary had submitted only 3 sections. 14, 31 and 32 on that basis said it's a special statute. Not referring to 88, 89. No. This point was not taken at all.
Give me those 2 dates.
So therefore, my lord, one is that, my lord. Next, my lord, only one small thing.
What
But
is
he
the
has
date of
said a
the
lot of
statement of
things about,
defense?
my lord, which are not within the scope of, within this. Papers also before you.
Huh?
He has said, I've been there, I've been present. My lord, these are things which I can dispute. I don't think that's going to take us anywhere. But the only point which I am trying to make out here, my lord, he has referred to some association where I'm a party. But is he saying that the association has gone to the radar? I'm not too sure about that. Some statement should be said with some
No,
kind
I
of
said the
responsibility.
the private.
Association is not there. They're all independent parties. And my learned friend has not dealt with the doctrine of election. That is what I'm on. I've shown 2 Supreme Court judgments, all 3 judges, my lord, on this point. He has not dealt with this. Grateful.
Well, only one thing factually, of course, my lord, Mr. Ray and I, my lord, should not be at variance with each other on this. So I'll also clarify with him. But my records say that the affidavit in opposition to the section 17 was, my lord, affirmed on 24th March. And the SOD, my lord, was filed on 20th May.
My lord, I'll keep that behind, my lord. Then let me just show your lordship just the starting paragraphs of both the applications.
I've seen it.
My lord, nowhere.
My lord, I think we disturbed your lordships enough, my lord.
But just to say this isn't correct, my lord. Section 16 is something.
I don't know, my lord. One says not maintainable, should be dismissed, my lord. Then arbitrability has to be specifically urged.
Jurisdiction.
Very well, my lord. We'll keep that in mind, my lord.
Well, page
If something is, my lord, not.
You want to
Malat only keeps these page numbers, Malat. Since he has said, Malat, we are both at logarithms on this.
Yes.
Page 809, Malat, of the supplementary affidavit. This happens to be, Malat, the affidavit in opposition. The notary, I don't know, Malat, we might be on variance on some pleadings, well, I'm not too sure. But what I have got, Malat, it shows that it was notarized on 20th of June 2025. And Malat, the statement of defense, Malat, it's in the stay application, page 136, which says that it has been notarized on 20th May 2025.
Must be there in the statement of defense.
Page 136, Malat. And your lordship must have seen the pleadings, Malat. There is not a single pleading, Malat. Kindly see there's only one paragraph in the statement of defense. Your lordship was of the view, have you taken this one in the statement of defense? But it just says claims are misconceived and liable to be dismissed with costs. Purported cause of action is barred by law.
I've seen that.
My lord, in my note, my lord, I'll give your lordship the page numbers and also, my lord, the portions of the statement of defense where, my lord, I have said, my lord, that I'm challenging
Your
meeting.
lordship also. Given. And then let us, by what time if your
3
lordship?
days.
Sorry, man.
Within 3 days.
3 days.
Friday must.
Monday.
I'm very grateful, my lord, for a
Let's see.
very, very patient meeting.
Aditya directed to file a written synopsis. Within a period of 3 days. Within 3 days.
My lord, maybe not destroy your lordship's weekend and maybe file it on Monday, my lord, just for the sake of preserving your lordship's weekend.
That's nice.
I'm
Very
grateful.
good. Monday. By Monday. By Monday.
Deeply obliged.
Friday what's Monday?
Monday.
Next.
New motion section 11 item number 5.
Lord, I'm for the petitioner, my lord. Learned advocate Mr. Abhilash Chatterjee met with a minor accident yesterday, my lord, and was injured. I'm playing for not today.
There was some settlement of settlement ultimately failed. Failed. We are still open for the development and they are refusing. Miss Praveen, every time the same statement.
I'm playing for one day accommodation, my lord.
What happened? The 2019 section 11 pending. What is this?
One day accommodation, my lord. He was injured.
Every time he makes the same statement. Proxy counsel states that the in our appeal counsel has met with an accident. She prays for an adjournment next week.
Next week.
Next week.
My lord, this is my application, my lord. My lord, kindly remember, this is the application section 11 filed in the year 2021. Thereafter, several occasion matter appeared. My learned friend prays for filing opposition. If used to not file opposition in the year 2022, he preferred an application before the consumer forum, got obtained an ex parte order. And my lord, I then mention it. And my lord, at my instant matter appeared. This is the agreement for purchase of a land.
There's the affidavit in opposition.
I could not find. Already matter has been mentioned before your lordship. But the advocate on record, who is the advocate on record, could not be find it out. So lordship, I filed the application GA, possible in the file. Yesterday I have filed before the department and I already served the copy to the other side by email.
What application?
Regarding recalling of the last order where your lordship was pleased to close my chance to file the opposition. And secondly, lordship,
You have been given the right
to file.
when were you given the first direction is in the year
21.
and we are sitting in 26.
Lordship. But thereafter, my learned
Give me
friend
the application. I'll decide.
Lordship.
It's not on record. Put it on record.
Lordship, date.
This has not been not on record. We'll dismiss with cost. Don't worry.
Lordship, I have already served him.
This will be dismissed with cost. Don't worry about that. Yes.
Lordship, I have already served him a copy through email, but could not. I shall serve the hard copy today. And all returnable date on notice of motion is on Friday. If your lordship so pleased to fix up the matter on Friday, I within this time to by today I shall serve the copy
Of the application, right?
of the application. And herein I have already paid for liberty to file fresh vakalatnama in the original AP.
I'm not concerned with your liberties. ये कब तक आ जाएगा registry से? Keep it tomorrow. We'll decide this application tomorrow. Keep it a special matter. We'll dismiss with cost.
But deeply of the. Well, matter.
Later. No. Okay. 7.
May it please your lordship.
Respondent, I have prepared a maintainability point of this application.
Yes.
If
what is
he's submitting on mental ability, let him finish his arguments, then I'll proceed.
Yes, but my point is not they have his claim arises out of a development agreement that was executed in 2007. Thereafter, an assignment agreement was executed, that is in 2011. And in that assignment agreement, I was introduced. That is Prithvi Infra Properties Private Limited, the respondent number 1.
Give the dates, wait.
First agreement is 5th December 2007. That is the development agreement.
5th December
2007.
is it development agreement?
Development agreement. That was executed.
You're not a party?
No, in that agreement, I was not a party.
Yes. Then?
Yes, sir. That was executed with one Defcons Private Limited. Now that Defcons Private Limited. That Defcons Private Limited was assigned to me. I was in the assignment agreement, I replaced him. That assignment agreement is dated 12th August 2011.
Yes.
Now I completed the development of the entire property. My developer's allocation I had taken and the owner's allocation was given to him. That given to him portion is in my opposition where he has accepted that his allocation. I would kindly see that opposition once. In my opposition, page 11, I'll not take much of time. Page 11 is the property I had developed. Page 11, 12, 13, 14, all pictures of the property that I had developed. Prithvi Residency. If my lord says page 12, my lord would see the signboard. And at page 15, that is the letter dated 9th March 2015, I write a letter to the petitioner herein, giving him his allocation, owner's allocation, para 2. In the premises, we are handing over the following flats in the said project to you as your landlord's allocation. So he had accepted this letter in 9th March 2015. No dispute regarding this letter has been raised anywhere in the petition. Now coming back to his abatement. Kindly see page 5 of the petition. His section 11 petition, page 5. His cause of action arises. How? He has mentioned in page 5, para 8. As it transpires, sometime in the year of June 2023, the flat from the owner's allocation, being flat number 2C, along with this, was sold to one Mongilal Barmecha by virtue of a deed of conveyance dated 24th January 2017. The respondent number 2 and 3 are the legal heirs of the respondent number Mongilal Barmecha, who has been made a party. Now, respondent number 2 and 3, he had made a party herein. Respondent number 2 had died. Respondent number 3 is alive, and 2 and 3 were the directors of Prithvi Infra Properties. Now, in arbitration, we have to see that whether they are party to the arbitration agreement. Respondent number 2 and 3 are not party to the arbitration agreement. Prithvi Infra Properties Private Limited can be a party to the arbitration agreement because in the assignment agreement I had entered. So I had stepped in the shoes of Defcons Private Limited. Now, respondent number 2 and 3 are not the parties. What does he say in page 5, para 8? He says, respondent number 2 and 3 are the legal heirs of the said Mongilal Brahmacha. Further, it is also revealed that a sum of rupees this has been received by the said respondents against the said purported sale, whereas the market rate for such residential unit along with covered parking was rupees 60 lakhs. Despite repeated...
Are they directors of this Prithvi?
Yes.
Both of them.
Respondent number 2 is no longer alive. Respondent number 2 has died.
That has not been given effect to the MCA records. MCA record still shows that respondent number 2
However,
is the director.
respondent number 3 could not be made a party because he was not a party to the arbitration agreement.
Respondent number
called for.
respondent number 1 is the developer. Number in the MCA records, it shows that these two are the directors who will be jointly and severally liable for the
How?
day-to-day functions of the company.
Why do you make them a party?
Cannot be.
Need to be made a party.
Cannot be.
They're not supposed to be a party.
Because, my lord, why I say so, your lordship? Because these are
It
the
is only with Prithvi. You make them a party. Why have you made them a party?
my lord, this is
And if he has
what has
expired,
happened, my lord. What has
he has
happened?
expired, drop them from the array of parties.
Yes, my lord, that can be exchanged. Respondent number 2 can be expunged, your lordship. But what has happened is, your lordship, I'll just indicate. If your lordship, if my learned friend finishes, then I'll proceed with the
3 minutes more.
facts.
I'll tell him now. It is completely dead. He says in para 8, starting only, as it transfers sometimes in the year June 2023, the flat from the owner's allocation was this. That means he came to know in June 2023 about this sale deed. He says on record in para 8. Now kindly see the sale deed once. Kindly see the sale deed once. That is at page 55. That would end the case. Page 55. The party of the first part is P3 Infra Properties Private Limited. Now the middle portion of page 55. Bagri Synthetics Private Limited, the petitioner. He had himself signed the sale deed. So how could he have come to know about in June 2023? Complete suppression and misleading facts. He has himself signed the sale.
There's also
Kindly
supplementary
let me complete. Kindly let me complete. You will always get a chance. He has himself signed the sale deed and given to the other party. So he was a confirming party in the sale deed. So how could he have said in the petition that he does not know about this? He comes to know about in June 2023. This has only been done to curtail the limitation period. Only to safeguard the limitation period. Yes. This is my contention. 2007 development agreement, 2011 assignment agreement, 2015 allocation handed over to the petitioner. Not refuted, no refusal or any allegation or any dispute regarding the 9th March 2015 letter has been raised by the petitioner. Now suddenly this petition was filed in 2025, claiming that in June 2023 I first came to know about this sale deed and that is why you have sold my allocation. Kindly arbitrator be fixed to decide the dispute. Now from the sale deed itself it can be seen that he has himself signed the sale deed. So how could he have said that in June 2023 he came to know? He's a confirming party there. He has signed it. I can show the signature part also. His representative has signed the deed. Page 55, the deed starts. The signing page, my lord, will find at page 79. Page 79, his representative signs, authorized signatory. In the middle portion, page 79.
File a 340, will send him to jail. File an application.
No, my lord, if I may just indicate. If your lordship kindly takes the first
Just
development
tell me,
agreement.
Forget about everything. Para 8. When did you get to know?
Well, this is not very well drafted, my lord. I'll
I'm not
just,
concerned.
if I may just read.
Not concerned.
My lord, I bow down.
I'm
bow down,
not
my lord.
concerned.
This is not the case, your lordship. How it has been
Anything
portrayed, my lord, it is
has
not the
been
case.
wrongly stated.
I bow down. I bow down.
Correct
my
the
lord.
facts first.
My lord, I'll just
Before we get anything into, correct the facts. When did you get to know of this?
my lord, that was in.
When did you get to know of this?
If I may just indicate, your lordship,
I'm not,
kindly.
I will not hear a word from you.
My lord, this sale, the 2017
You want me
sale.
to take it so
No,
moto,
my lord, just give me 1 minute.
client to jail.
Kindly gives me 1 minute.
Listen,
My
must
lord.
you clarify this fact to the court?
My lord, I'm trying to clarify.
Yes,
my lord.
tell me.
Yes. In 2017, my lord, the property, this disputed property was sold to a third party, and I was a confirming party. That's given from the
How
record.
did you write this?
My lord, my lord, entire paragraph has to be read as a whole, your lordship. In a supplementary affidavit, my
I
lord,
will read the entire paragraph.
I'll read it.
Read it.
As it transpires sometime in the year 2023, the flat from the owner's allocation, being flat number 2C, along with one covered parking spot, was fraudulently sold to one Mangilal Barmecha by virtue of a deed of conveyance dated 2017. The respondent number 2 and 3 are the legal heirs of the said Mr. Mangilal Barmecha, and further it was revealed that the sum of rupees 39 lakhs has been received by the respondents against the purported sale. for such a residential unit along with a covered parking was rupees 60 lakhs. Despite repeated requests, the respondent has failed to transfer the sale proceeds of the said flat in favor of the petitioner, thereby causing huge economical distress and financial loss. Again, on 29 December, this will be 2022, my lord. The date is wrong. The said flat has been sold by the Mangalal Barmecha to the third parties. The legal is to the Bhattacharyas, Mr. Deepak Bhattacharya and Mrs. Priyanka Banerjee. So, my lord, this is the drafting, my lord, may have not been, my lord, I'll
Withdraw this and file a better draft. Or I'll send you this person for stating this on oath.
my lord, this was pointed out on the last occasion before the other coordinate bench as
I'm
well.
not concerned with the other coordinate bench.
My lord, I bow down. I bow down, my lord. But what has happened?
You are
Your lordship?
concerned with this bench.
Absolutely. I bow down. There's no doubt, your lordship. My lord, what has happened?
Either
If
you
your
withdraw
lordship
this,
kindly take the document one.
I'm not concerned. Nobody can file a false affidavit in this court.
Absolutely. I bow down.
There are consequences of it.
Please, I bow. No, this has not been.
I'm not concerned. You either
In that
withdraw.
event, my lord, I should withdraw, my lord. With a liberty, your lordship, kindly.
Learned counsel for the petitioner seeks to withdraw the present petition. Same is dismissed as withdrawn with liberty to file appropriate proceedings in accordance with law. How can they take the court for a ride? They can file anything. This is only to counter your payment, nothing else.
My lord, will kindly not take me amiss, your lordship.
This is not done. Not done at all. Anybody can state any fact contrary to the record. And we should bear with it.
Deeply obliged, my lord.
Deeply obliged.
8.
This is my section 11, my lord. Even on the last day, my lord, none appeared for the respondents, and on my prayer, my lord, my lord was pleased to grant me, my lord, liberty to, my lord, serve the learned advocate, my lord. I have served him. I have communicated that.
Or the respondent.
My lord, my prayer was, my lord, on the advocate, but from the order it seems, my lord, that my lord has recorded respondent. So I can, very well, my lord, kindly grant me, my lord, I have served the advocate also.
Why do you serve the advocate?
It was
respondent.
my misunderstanding, my lord. Kindly grants me, my lord.
Order records respondent.
Yes, my lord, but my prayer was, my lord, for advocate. Very well, my lord. Kindly, my lord, grants me an opportunity, my lord. I have communicated to the advocate. He has not.
Learned counsel for the petitioner seeks and is granted further time of 2 weeks to comply with the order dated. What is the date of the order?
It was, my lord, 4th of August.
4th of August. Just after 3 weeks.
3 weeks.
After
9.
On the last occasion, your lordship was pleased to send this matter into mediation. The mediation process is still pending, lordship.
Learned counsel. When is the next date in the mediation?
28th this month.
Learned counsel for the petitioner states that the matter is still pending before the mediation cell. He seeks an adjournment. Let this matter be listed after. How much time will it take? After 4 weeks?
Lordship, 4 weeks.
After 4 weeks.
Grateful, lordship.
Not 10.
My lord, this is my application, your lordship. This arises out of a memorandum of understanding. If your lordship kindly
Who's
take.
on the other side?
My lord, they have been served, your lordship, but they are not appearing.
The connect affidavit of service.
Filed it.
No track report.
Not the service. Very well, my lord. I'll serve and come back, my lord. a fresh direction may be given for.
Copy for the petitioner seeks and is granted 2 weeks time to effect service upon the respondent. List after 3 weeks.
Well, great.
No track report is
My lord, I'll 10 and 11. 10 and 11, my lord.
3 weeks. 11.
My lord, dispute between same parties, my lord.
serve them.
I'll come back.
Same order color.
Same order.
Can affidavit serve the court?
And not 12. Oh, sorry.
Same issue.
I'll come back, my lord. Grateful.
They said that 2 weeks, 3 weeks. And not 12.
I'm for the petitioner, my lord.
Yes.
Lord, if your lordship kindly take up this matter at 2 p.m., my lord.
Why?
My lord, I'm led by Mr. Shubhashish Sengupta.
All right, 2 p.m.
My lord. Grateful, my lord.
Before my lord rises, my lord, may I mention one matter, my lord, since there may be a,
The time for
my
mention.
lord, since there is a resolution, my lord, there may be a resolution in the second half, my lord.
Very good.
Item number 29, my lord, it's my execution petition, my lord, unilateral appointment of arbitrator, my lord, instructed by my client to oppose, my lord, but my lord had passed several judgments on this aspect, my lord. I was only praying, my lord, that my lord may pass
You are
the.
appearing for?
I am appearing for the petitioner, my lord, in item number 29, Cholamandalam Finance, my lord.
Let me come back.
Very well, your lordship.
See page 61, paragraph.
With the resolution also, I see a lot of people.
Item 12, Your Lordship, this was the section 11 where I had taken this objection that this should have been in the commercial division because this arises out of a development agreement.
Yes, Your Lordship. I am also ready with Your Lordship all the judgment. Actually, there is little bit confusion. Your Lordship, this as indicated on the earlier occasion, Your Lordship, this decision we take as a lawyer. Clients, they don't take. Now, in a development agreement, Your Lordship, the main motto of Your Lordship is of the developer is to earn profit, and the owners, Your Lordship, they give the particular property, Your Lordship, so that they can get allocations of the property. Now, Ambalal Sarabai's judgment, Your Lordship, clearly says that is the nature of the property which is to be looked into. In my matter, Your Lordship, the property, Your Lordship, is Bastu. We have applied for Your Lordship the application for sanction plan for residential purpose. So that's why Your Lordship, I have framed Your Lordship the section 9 as well as section 11 here as a non-commercial
It
matter.
is arising out of a development agreement.
Yes.
There are commercial transactions. Even if it's a Bastu, you have applied for the sanction plan.
Yes.
Ultimately, commercial profits are going to flow out of it.
Yes, if Your Lordship asks me regarding that, Your Lordship, it has to be. Lordship, because developer, Your Lordship, the main intention is to earn money. Yes. Now, we find out, Your Lordship, some judgments which says that if it is development
If
agreement.
it's an academic exercise.
I know, Your Lordship, it's of no use. I will consent, Your Lordship, regarding the commercial and non-commercial. My problem is not that. Section 9, Your Lordship, I obtained an order. And that section 9, Your Lordship, I filed it, Your Lordship, in a non-commercial. If I consent here, Your Lordship, my orders will be vacated. And they will, Lordship, they will deal with the
I
problem.
have taken the same point there as well, that the court did not have jurisdiction.
So that's the only problem. Otherwise, if it is academic, I will consent because commercial, non-commercial, Your Lordship has the determination.
Lordship, I'll just
But my problem, Your Lordship, is regarding that. The moment I say, my order will be vacated. If they consent, Your Lordship, that they will not, I understand, Your Lordship, they can't. But if they, Your Lordship, agree, then the whole problem will be sorted out. An arbitrator may be appointed, Your Lordship, and I'll go and apply before the my interim prayers before him. But they will not agree, Your Lordship, regarding that.
my learned friend is also not agreeing that this should be a commercial.
No, I will agree. I will agree. Provided, Your Lordship, they will also agree at least that till that date I go before the honorable tribunal, they will not, Your Lordship, the interim order will continue. All problem will be sorted out. I will not show at least 6-7 judgments. He will not show 6-7 judgments, Your Lordship, the time of the judicial, Your
That's
Lordship.
much better. Let
My
him
instructions are that we are contesting the section 9 on that ground itself. Is my
on what ground?
it's not that it was filed in a non-commercial division in the before Barasat. And I've taken the point that since this arises out of a commercial agreement, this has to be. And Lordship, this distinction is provided in the Act itself, subject to what your Lordship, what falls from your Lordship, I'll place judgments. 2.6 says of the commercial suits, construction and infrastructure contracts, including tenders. So any construction agreement or a development agreement or a joint venture agreement.
Yes, sir. Commercial.
ওটা তো বলবে না
Section 216 C6, your Lordship will see construction and infrastructure contracts has been specifically provided. There's a separate proviso which provides for agreements relating to immovable property used exclusively in trade or commerce. So these are two distinct categories. If I file if my cause of action is with regard to a lease or title of a lease of a property which is used as commercial, then it would come under 2.7. But if the contract from which the dispute is arising is relating to construction or development, or is an infrastructure contract, then that has to be commercial. So it is not covered by Ambalal Sarabhai in my respectful submission, because that deals with an immovable property used exclusively for trade or commerce. I fall under 2.6, which relates to construction. And your Lordship, I'll just place the deed I'll just place the development agreement and show the clauses. Kindly takes up the development agreement at page 19. So the development agreement starts at page 19. Your Lordship will kindly come to page 24. Your Lordship will see 1.3 saleable space. It says what are shall mean the space within the building which is to be available as an unit or a flat for independent use and occupation in respect of owner's allocation and developer's allocation. Landowner's allocation, it is specified the landowner will get total 35% constructed area, including staircase, lift, lobby. and the developer's allocation, here it is states it shall mean save and accept the owner's allocation as mentioned herein above, all the remaining constructed area of the proposed multi-storied building. So he has a 65% stake in the building. Thereafter, if your lordship comes to page 26, clause 4.2, right of construction under Article 4. The landowners hereby grant permission in hereunder provided exclusive rights to the developer to complete the building upon the said land measuring 10 kattas, 4 chitaks, 90 square feet more or less in accordance with the plan sanctioned by the competent authority in the name of the landowners or developers with or without any amendment and or modification thereto to be made or cause to be made by the parties thereto, and the landowners hereby exclusively grant to the developer to develop the property. So he is given a right of construction. Kindly sees 4.4 construction cost. The developer shall carry out the total construction work of the proposed building at their own cost and will take the sale proceeds of developer's allocation exclusively. So he is commercially benefiting out of this. Kindly sees thereafter 4.7, the profit and loss agreement. The profit and loss earned from the project will be entirely received or borne by the developer, and no amount will be adjusted from the owner's allocation on account of loss or vice versa on account of profit from developer's allocation. So he's also getting profits out of it. Kindly sees Article 5, clause 5.1 at page 27. It specifically states that this agreement is to commercially exploit. 5.1 says permission. At page 27, if your lordship will. The developer have agreed to build the said proposed building at their own costs and expenses, and landowners shall not be required to contribute any sums towards the construction of the said building or buildings on the said premises, and to commercially exploit the said premises. The developer have agreed to provide the landowners the space defined in the owner's allocation. So this agreement, development agreement which the landowner and developer enter is only for commercial benefit.
Section 9, you have, you're supposed to file your reply in section 9.
Yes, right. My instruction says it's already been filed there.
No, they have they have filed a vacating application, Your Lordship, and dismissal of my application.
Have you filed your reply to section 9?
He says he'll have to take instructions.
What is the odd?
I don't know if he's the aver in the Barasat as well. He thinks there's some other advocate engaged in Barasat, so he'll have to take instructions. So there apart, I have one judgment to cite. There are in fact two judgments. One of single bench, pat on the point.
This commercial contract. I'll hold it against you.
I'll show you, Lordship.
It has to be commercially exploited. It's just that you'll make me do all the exercise.
All development agreement, Your Lordship, is required to be commercially exploited. A developer is whenever a developer's, Your Lordship, comes in.
So non-commercial side, you show me judgment.
Yes, Your Lordship. May I only show Your Lordship the two things, only two things, Your Lordship, which is required to be shown. Otherwise, all the agreements are more or less same.
So let him file his reply if you want to contest on this point. Let us have a judgment on this then.
Very well.
Academic exercise.
Yes.
Very well, Lordship. I'll file my objection then. Opposition.
Take down learned counsel for the petitioner has filed the present application under section 11(6) of the Arbitration Conciliation Act, seeking appointment of an arbitrator. Seeking appointment of it's a sole arbitrator, right?
Sole arbitrator.
Sole arbitrator to adjudicate the dispute between the parties arising out of the what agreement is this?
Development
agreement dated 12th February 2024. Learned counsel for the respondent at the threshold states that the present application is not the present petition is not maintainable since the same has been filed on the non-commercial on the non-commercial side. Learned counsel for the petitioner controverts the said contention. Learned counsel for the respondent seeks and is granted. How much time?
Kindly grants me 2 weeks.
2 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. I think the maintainability of the said petition on the ground that the same has been filed on the non-commercial side. The said contention is controverted by the learned counsel for the petitioner. at this stage. This court grants 2 weeks time to the learned counsel for the respondent to file their affidavit in opposition, reply to the same if any within 1 week thereafter, just after 4 weeks.
1 week may be given to me for
I
reply.
gave you one.
Yes.
2 weeks, 1 week.
May I file your lordship affidavit of service and notice of motion?
Affidavit of service, notice of motion, stick on. All academic.
Yeah, I gave a proposal, your lordship. I know he will not be prejudiced. If your lordship, the interim order, your lordship may continue and I go before the tribunal. All problem will be sorted out.
Interim order is prejudicing.
I am enjoying an interim order. Not from today, at least for 2 months.
So today, if I dismiss this, then
If your lordship dismisses the same, I have to again, the interim order will be there.
you'll
But
get the
again, I have to take the immediate steps, your lordship, to go before trial before the commercial court. Only regarding that
What will
particular leverage, your lordship, I am asking, your lordship. For that, if he is not agreeable, your lordship, it will take 1 day, your lordship, to go before a commercial court. I know. But the thing, in the meantime, if he deals with that particular property, I will be prejudiced. Nothing will happen. I'll go before the tribunal, file a section 17. Till that date, your lordship, I am praying for an indulgence. What?
He doesn't have the instruction. They all are creatures of the instruction.
Examination of judgment letters, item number 44. Examination of judgment letters, item number 44. Signas Investment and Finance versus Raja Chakraborty and others.
Yeah.
Yes, who's there?
Our said is not here. However, have taken decision not to take part in judicial proceedings from two. Sub the copy.
No, but I'll record her presence.
Yes.
She is judgment data number
3. I'm paying you to file the court copy. Sub already the other
and appears on behalf of the
Key asset.
I take happy to say.
award holder.
Yeah.
The judgment data number 3 is present in the court. Let this matter be listed for the examination of the examination of the judgment data after 3 weeks.
3 weeks.
Affidavit.
ওটা কি দিলে?
You have filed your affidavit.
Number 3. Yes, yes, John. I've already served.
What is this?
He is the daughter of the main person. I mean, sister of the 1 and 2 and daughter of
Is your affidavit of assets?
assets.
Affidavit of assets.
I've served.
Filed by
I've
the
served.
September 3.
একজন কবে হলো? 45.
Malad, before the matter starts, Malad,
Judgment letter.
Malad, I would like to bring to notice, Malad, it's an award of 2018, but it's an unilateral appointed award.
But I have a section 47 on that. That since it was unilaterally passed, it's a nullity afterwards. So
Malad, that's why I brought it. I was trying to find a way out because they have unequivocally admitted that they had received a 21 notice and they admittedly did not take any steps. That's mentioned in the application. So I was trying to find a way out if there was any way out in my lord's judgment. But since it's the case, Malad, I thought to bring it to a notice that.
Withdraw it, I'll give you liberty.
Malad, there's no other way,
The
Malad.
petitioner seeks to withdraw the present petition. वो जो है ना with liberty to initiative.
Minister দেবেন একটু।
All connected application.
47 also disposed of.
45 and 47 is
No,
what?
no, no. Lord, our section 47.
Malad, the GA2, my lord.
Yeah, all along.
Application. Malad, liberty to.
Liberty.
Oblige, your lordship.
In respect of the item number 44, my lord, I am coming, my lord, Mr. Meghnad Datta for surgery, my lord, he did not come to court, my lord. Your lordship, my lord, adjourned 4 weeks, my lord.
3 weeks.
3 weeks.
3 weeks.
3 weeks. Look at the watch.
Yes, my lord.
Look at the watch.
Yes, my lord, I appear before there is a resolution, so my lord, I not appear.
Resolution doesn't mean I'm here. You don't want to appear, don't appear.
Resolution is there.
That's what I thought. Nobody will be here. But why are you?
সপ্তাহে একজন
None appears for only for not today, because otherwise client, otherwise client will otherwise client will say you are not. Yes.
She was here in the court. She had come today. She came for examination.
I morning inform my lord. I morning inform her my lord.
Yes.
3 weeks. 3 weeks.
Please.
46.
Lordship, we are withdrawing the executive petition.
No.
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 Gratefully, Lordship.
What did it say?
Item number 47, this is fixed for examination. This is unilaterally appointed. Kindly, my lord, it is withdrawn as an judge on the ground of judgment, my lord. This sample order.
What is it? 47.
I'm good.
নাম রঞ্জিত সিং সুবর্চিতা, ঠিক আছে।
Your Lordship,
48.
liberty may be granted.
8, my lord. I am for the award holder.
48, no? 48.
48, 40.
48.
48, my lord. 48.
45, 46, 47, it is.
This is my there was a direction to file.
I'm handing over a copy to my one.
Only one word. No, the last occasion there was a direction to file affidavit of assets. Yes.
Grateful.
Dictate.
একজন 2 weeks দামগুলো দেবেন একটু। এটা ওনারটা দেয়নি। 47 রিয়াদ নিয়ে চলে যান। 49.
Lord, I appear for the award holder. Lord, in terms of your lordship's last order, Lord, the award letter number 2 was to file its affidavit of assets. Very well.
50.
Lordship directed me to appear in this matter, my lord. I have not received the copy of the brief from the department, my lord. Kindly take it up after. Yes, sir. Yes, sir. Yes, sir.
Mark her.
And now 50.
Just take down so and so Union of India. None appears on behalf list after 2 weeks. Next also nobody for Union of India. Who's there?
51.
51. None appears for the Union of India.
I appear for the respondents.
Miss, you're there? Miss
There.
Because of the resolution cannot be.
Not today.
The resolution.
Which one not today? 52.
50
And now 52.
Even not today. 52 not today. Not today.
53.
Not today.
54. 54.
Not today.
55.
Not today.
I pay for the respondent in this
Not
matter.
today. Not today. What are you
50
doing? Are you filing something?
My lord, the supplementary affidavit, my lord.
What is the supplementary? Not today. Let it be.
56. Not today. 56. 56.
Lordship, I'm led by Mr. Devnath Ghosh.
Not today.
57.
Not today.
58.
Not today.
59.
Not today.
60.
Yes, Mr. Nag.
Item number 13, your lordship.
No adverse orders today. What's the point of calling? What do you want?
Tomorrow.
We'll come back to 17, 18, Milord, 19. That matter, when Milord,
They won't come today.
to withdraw the money. We'll come back tomorrow.
I even